before I bring the jury down? Anything before I bring down the jury?
Want to do that after? There are several matters, but I think that the state and myself would prefer to discuss that after the opening statements have concluded.
All right.
I do have one quick one, and that is that the court yesterday signed a material witness warrant for a Miss Swanigan.
I didn't, but one of the judges did.
Oh, some other, I apologize.
Judge
I thought the court did. We're asking the court to cancel that at this point, pursuant to contact with our office when the warrant went out. She is physically here and is at the courthouse, and so I believe she's in compliance with what we were hoping to accomplish. So we'd ask the court to allow that to be dismissed at this point, and we expect her to be a witness today.
Did you have comments?
No comment.
Your wish is my command. All right. Anything else?
Anything else can wait.
All right. Not to be down. I suppose they messed around with those. Get back to some journal. Yes, would you come down, please? Thank you. All right, good morning, everyone. Welcome back, and we had some discussion, and then the attorneys consulted, and it's decided that the objection which was raised by Mr. Gravely has been withdrawn. So we'll continue where we were.
Thank you, Judge.
Ms. Miller, thank you.
Good morning, everyone. So where I had left off when I last was speaking with you all was about how law enforcement in this case failed to actually investigate the events the state assert transpired on May 17th, 2020. How they ignored leads, how they didn't follow up on things, how they failed to look in places that should have been looked into. So I'm going to go into some of those investigative failures now. You'll hear that law enforcement really did no searches of Mr. Gutierrez around the immediate vicinity of Wood Creek Apartments where Mr. Gutierrez lived. That there's a wooded park area that is property of UW Parkside, and that all that they did with that area was send some drones to look around. But you'll hear that it was forested at that point because we're in the middle of May, and that they would not have been able to see the floor of that entire wooded area. So law enforcement looked nowhere close to Mr. Gutierrez's residence in an attempt to find potential evidence. Not only did they fail to do that, they failed to investigate legitimate Crime Stopper leads. So people could call in with tips, anonymous or not, and there was this one tip where an individual called in and said, I saw a woman standing in front of Mr. Gutierrez's sliding door on that concrete slabbed patio on May 18th, 2020. And I remember this because she had asked me what time it was. And I knew it was Mr. Gutierrez's apartment because his sliding door is right next to that exit door. Law enforcement got that information and ignored it. They did not follow up. They also didn't follow up on data that they obtained through a geofence warrant. And you'll hear that a geofence warrant is where law enforcement takes a certain area and asks Google to produce all the information and data on people that they know were in that location on a specific date and during specific time frames. And in this case, Detective Carrera had asked for the geofence data on all individuals who were around Mr. Gutierrez's apartment from May 17th, 2020 at 7 p.m. through May 18th, 2020 at 3 a.m. And that Google produced several hits for people that were in that area. And you'll hear that law enforcement did not attempt to investigate any of those potential people who were in the area at the time the state asserts the crime occurred. You'll also hear that Mr. Anderson did not appear in that data. When law enforcement arrived on scene on May 19th, 2020, there were two dumpsters next to Mr. Gutierrez's apartment, and they had gone and looked at them and noticed that there really was not that much trash. Maybe a bag, a box, and so they called the waste management company and they asked, hey, when was this trash picked up? And the waste management individuals had informed them that the trash had been picked up earlier that morning on the 19th and that it was sent to Zion landfill in Illinois. You'll hear that law enforcement chose not to go to Zion landfill and search what would have been freshly dumped garbage that could have produced evidence in this crime. And you'll hear that that could have been because Mr. Anderson, the person, remember, that they had chose as their main character, there was no indication that he had ever gone out to Zion or that he had spent any significant time in the Kenosha area. Didn't fit their script. They weren't going to investigate it. They also didn't investigate Pheasant Run landfill. That was a landfill that they had potential information that Mr. Gutierrez's body had been dumped there. They didn't go to Pheasant Run landfill. They didn't talk to anyone in management at Pheasant Run landfill to see whether there was any individual who dumped off trash that Monday, May 18th, that morning. They did not investigate that lead. They also didn't investigate people that Mr. Gutierrez owed money to. And you'll hear throughout this case that Mr. Gutierrez was in an extremely difficult financial situation. His mom was helping paying bills. He was about to be evicted from his apartment. And he had people messaging him about where their money is and how you don't do this to friends. And you'll hear that law enforcement did not investigate a single person that he seemed to owe a substantial amount of money to. And then they also didn't look into all of the women that Mr. Gutierrez would have been talking to or dating at that time. You'll hear that Mr. Gutierrez had several dating apps. They were located on his phone. He had emails from dating websites, and that law enforcement didn't look into any of the chat strings on there. And that's just the tip of the iceberg. What I just outlined for you is just a little sprinkle of an example of everything that law enforcement failed to investigate. But not only did they fail to investigate legitimate leads and potential other suspects, they also failed to effectively process the scene of the crime. They failed to obtain DNA swabs, fingerprints from areas that, according to their theory, the individual or individuals who was responsible for the disappearance of Mr. Gutierrez would have had to have touched or come in contact with. The first thing law enforcement did when they arrived on scene on May 19th, 2020, was they took a video of them walking into the apartment, of Mr. Gutierrez's apartment, and all of the lights were off. So the state claims that there was this blunt force trauma, this beating, someone was wrapped up in a rug, the crime scene was meticulously cleaned up so that no trace of the other people who were there could be found, that then the scene is staged to the point that it looks like a robbery could have occurred. That obviously didn't happen all in the dark, if they're claiming that this happened around 10 p.m. at night, yet law enforcement did not swab the light switches in the apartment for potential DNA, nor did they attempt to get any fingerprints. In addition to their failure to obtain swabs from areas that could have contained DNA of the people who are actually responsible for Mr. Gutierrez's disappearance, their lack of precision shows immensely in the fact that 9 days after they initially made contact with Mr. Gutierrez's apartment, Mr. Gutierrez's mother, Ms. Patterson, found Mr. Gutierrez's cell phone in the freezer. That law enforcement's there for 8 days. They'll claim that they searched, they processed, they were very thorough, yet they didn't find Mr. Gutierrez's cell phone that was right there in the freezer, or the contents of his wallet that were in the freezer. So they did swab the cell phone for DNA, but what they didn't swab or process for fingerprints were the cards that were found, which, according to the state's theory, the person who's involved in Mr. Gutierrez's disappearance would have had to touch, to take out of the wallet, to put in the freezer. And they also didn't process the handle of the freezer. It's also critical that there was no blood on the handle of the freezer. And the phone, interesting enough, the DNA, they send the swab that they took to the crime lab, and it comes back and they say, yep, it's Mr. Gutierrez's DNA on the phone, but there was something that's called a trace allele. And you'll hear from the DNA expert that a trace allele means that it's someone else's DNA, that it's a portion of someone's DNA that did not belong to Mr. Gutierrez, but someone else. And you'll hear that that trace DNA that they found on that cell phone, as I just said, did not belong to Mr. Gutierrez. It did not belong to Ms. Patterson, the individual who found the cell phone, and it did not belong to my client, Mr. Zachariah Anderson. So someone else's DNA is on that phone. You'll also see pictures and hear testimony about how the furniture in Mr. Gutierrez's apartment had been moved. And all of this furniture had been meticulously moved. Nothing's knocked over, nothing's broken. The kitchen table's nicely pushed back. The two white tables that were in front of the couch were nicely moved to the side. The couch had been moved, and we can see that because there's indentations in the carpet of where the couch had stayed for a long time versus where it was now. There were no bloody fingerprints or hand marks on the bottom of the couch. They didn't process that for DNA in that area of a couch where the person had allegedly moved it, would have had to have touched. They didn't process the areas of the chairs that would have needed to have been moved, the table that would have needed to have been moved by the person who's allegedly responsible for the disappearance of Mr. Gutierrez. They also didn't process the tools that appeared to be nicely laid out in front of the screen door. Nor did they process in Mr. Gutierrez's bedroom the open window. They didn't process that for fingerprints. What did they do? They processed the blood. That was it. Law enforcement's failure to investigate leads and to effectively process a crime scene is critical in this case. There's no body. no human remains, no murder weapon, no witnesses that can tell you exactly what happened. Yet they wanted to go with the narrative that it must have been Mr. Anderson, and that was someone that they looked into everything possible. They ignored everything else. They ignored the idea that it could be anyone else other than Mr. Anderson. And you'll hear that they meticulously searched Mr. Anderson's property, not just his house, his whole property. No body, no human remains, no evidence that there had been a huge cleanup at a crime scene, no murder weapon. Not only did they search his house, they also searched his family's tree farm, an 80-acre farm, top to bottom, multiple law enforcement agencies, every acre, no body, no human remains, no murder weapon, no evidence of a crime scene cleanup. They also searched Miss Susan Brown Williamson's home, and that was the place that Mr. Anderson had gone in the morning to work, that the state claims is where Mr. Anderson, I guess, chopped up a body and put it in bags. They searched that property meticulously, not only the house, but the entire grounds. No body, no human remains, no murder weapon, nothing of evidentiary value. They then searched all of the bodies of water that were near that home and Mr. Anderson's home, not Lake Michigan, but quarries and little lakes. And they had technology that could go all the way down to the bottom to see if there was anything there. That search also revealed nothing. So the person they chose as their main character, the only person they investigated in this case, they did all of that and it yielded nothing. Mr. Anderson, as he sits in front of you today, is presumed innocent. And he must stay that way. Because the evidence in this case, as it will come in through this trial, will not establish that Mr. Anderson committed the alleged crimes beyond a reasonable doubt. And for that reason, when the defense comes and speaks to you, when the evidence is done, we will ask that you return the only just verdict, and that's a verdict of not guilty. Thank you.
All right, folks, we'll start with the taking of evidence at this point. And as I indicated Tuesday, you'll be allowed to take notes if you wish. You're not obliged to. If you do decide to take notes, please take care that it does not distract you from carefully listening to and observing the witnesses. You may use your notes during your deliberations to refresh your recollections. Otherwise, you should keep them confidential. After the trial, the bailiffs will collect the notes and they will be destroyed. Okay.
Judge, can I be heard briefly?
You can.
As part of my withdrawal of my objection, the court will recall that we proposed a cautionary instruction. So the withdrawal of that motion was based on the cautionary instruction, which I hope the court will read.
I will, and I even told them that you'll have to remind me because I'll probably forget it. Thank you, because I did. This is a joint proposed cautionary instruction that the attorneys have agreed upon, and it states, unless otherwise guided by the court, you must disregard any statement by the attorneys or either of them that any specifically named individual other than the defendant was involved in the alleged homicide of Mr. Gutierrez. Any question about that? This is something they've agreed upon. Unless I tell you otherwise, you should disregard any statement by the attorneys that any specifically named individual other than the defendant was involved in the alleged homicide of Rosario Gutierrez Jr. Any question? Okay, thank you. All right, Mr. Gradley, you might call your first witness.
several things that before the first witness is called that the parties would like to address with the court pertaining to stipulations and things of that nature. So I believe that would be more appropriately done now before the first witness is called.
Okay, so that's legalese for scram. Now you can go, and I'm going to try again to keep it at just a couple of minutes. But you're welcome to go upstairs if you want, or otherwise you may remain down here in the library. And I'm hoping this will take under 10 minutes, maybe 5. Okay, thank you. In the meantime,
What are we hoping?
if I can talk to someone from Court TV, I can't get my computer cranked up this morning, and I'm wondering if something got detached while you were up here. I'm not blaming you. I don't want to call IT unless I have to. It won't stay on. I mean, the light goes on, so there's power. entitled Stipulated Facts Regarding Statements of Unavailable Witness, Lene Douglas. And would you like it read or just in the record? And at the appropriate time, it'll be given.
Yeah, I'd like us to be able to read it to the jury as part of the evidence. My proposal to the court is that at a time that I would have called Ms. Douglas, which will be this morning, which is why we bring it up now, that the court will allow us to read it. I will either read it in its entirety, or if defense counsel wishes to in some way read the first portion, the paragraph that is regarding Officer Paul Chase's report, I of course have no disagreement with that. And then I will read the second half to the jury. And then of course the court can have that stipulation in evidence, but we'll read it. I'll read it verbatim, or we will both read it verbatim. Ms. Douglas is having medical issues that both parties are aware of. That's why we've tried to reach this stipulation to prevent her from having to be present. She has no prior convictions, so in terms of any impeachment, we're also aware of that.
Is this a correct statement of the stipulation? That is correct. Are you familiar with this?
That is correct, Judge, and the defense would prefer that we read the portions as it relates to Officer Paul Chase's reports, and then the state will read the portion as it relates to the telephone call that was had with their victim witness coordinator, Heather Beasy. So that would, and we have no objection to it being read at the point where the state would have called Lene Douglas. We think that's appropriate because that will be around the time that other residents of Wood Creek apartment will be called. So it would only make sense to read that stipulation in then and there. I have given a copy of the stipulation to Mr. Anderson. He has read that and is, as far as I know, unless it's changed now, is in agreement with the stipulation.
All right. Do you fully understand what is contained in the stipulation? And any questions about it at all? By stipulating this, that means the witness will not testify, and instead the jury will be read this stipulation, and it's stipulated facts. That means that the jury will be instructed that those are proved facts in the case, and there'll be no testimony admitted either to reprove those facts or those assertions, and there'll be no testimony permitted to disprove it. The stipulation means it's agreed. Is that clear?
Yes.
Any question about this at all?
No.
Has anybody threatened you, pressured you, or forced you in any way?
No.
Has anybody promised you anything in exchange for this? No. All right. Anything else then before we start?
Just that the first witness the state intends to call, Detective Lauren Anschutz, has no prior convictions. And another witness that we would call, hopefully without needing an additional break, would be Marissa Swanigan. She's the individual who's here on the warrant. She also has no priors. And so I believe that in terms of these early witnesses that we would call before there would be any additional breaks, that I think we've met our obligation to let the court know about any prior convictions.
Okay.
And we are in agreement with that calculation to the witnesses that the state just mentioned, and as the state said, we'll work diligently in getting the other convictions for the other witnesses to present to the court at a later time.
So let it be written, so let it be done.
I believe we're ready then, Judge, at
All
this
right.
point. Counsel, do you agree?
Yes. Well, unless
All right. How did we do that time-wise? Pretty good? All right. Close? Okay. All right, thank you. Go ahead, Mr. Gately.
Your Honor, the state calls Detective Lauren Anschutz to the stand.
Is he out of the room?
He's being brought, he was outside, he's being brought in by our victim witness person.
Okay. I do solemnly swear the testimony you are about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please be seated.
Detective Anschutz, can you state your first and last name and spell both your names for the record?
Lauren Anschutz, Lornanschutz.
Detective, how are you employed?
City of Kenosha Police Department as a detective.
How long have you been a detective?
Approximately 7 years.
And how long have you been a police officer with the Kenosha Police Department?
Just under 20 years.
During that time period, have you had an opportunity to investigate scenes where blood was present?
Yes, several.
And do you have an estimate in your 20 years how many times you've come across a scene of that type and had to make some sort of decisions regarding either what to do next or what there was there?
It's several hundred.
In that capacity as being on duty as a detective, did you come on May 19th, 2020 at just after 11 a.m. To be at a particular location that you were asked to go to?
Yes, I was told to go to 3709 15th Street for a suspicious incident.
And when you got there, were you the first officer on the scene?
No, there was multiple officers, a sergeant, another detective, and yeah.
Would that be uncommon that other officers would get there before a detective for a call like this, or would that be standard that detectives would not be called in as the first officers to arrive?
Yeah, I've never been called first as a detective to respond to any scene. Typically, the officers will respond, make an assessment, talk to a supervisor, and then we will be notified to respond.
And when you arrived, I don't want to know all the details, but what were you in general appraised of? So what were you told in general was the situation when you arrived before you made observations for yourself?
I was told that apartment 1B had a substantial amount of blood inside. It appeared as though there was a major incident occurred in the apartment and nobody was located.
And was that information provided by law enforcement?
Yes.
Were you provided information that the person reporting this was still on scene?
Yes.
And did you have a chance to interact with that individual?
Yes, I spoke with her, Sadie Beacham.
Okay.
Sadie Beacham was on scene. She was sitting in her car at the time I spoke with her.
And did you come to believe that Ms. Beacham had not fully entered the threshold of the residence, had not walked through the residence before calling law enforcement?
Correct.
Okay. So based on that, would your role in this case be to specifically search for a body or somebody within that residence, or would that be the role of other people who were at the scene?
That would have been the role of the responding officers to preserve life, to make sure the scene is secure.
Okay. And back before you were a detective, were you in that role many, many times over your career?
10 years, yes.
Okay. And so in that earlier role than yours, would it have been a priority to search for a person and not worry about what the evidence was, or are you already an evidence preserver in that first role that you described?
I'm going to object as far as leading.
Well, it had an alternative, so the objection is overruled.
Go ahead.
Can you rephrase, or can you
Sure.
Give me the question again. Sorry.
Sure. In that earlier role, is the priority to do the search as quickly as possible or to meticulously try to preserve evidence, like not step in things, et cetera, et cetera?
In those situations, you're concerned about the safety of others. That's your main focus and priority at that moment. As well as scene security. We don't know if anybody's in there. So that's what you're vigilant of when you first enter. And then obviously after you can slow down and then focus more on the preserving of evidence.
So I want to turn your attention to the address one more time. You said it was 3709 15th Street, apartment 1B. Do I have that correct?
Correct.
And do you know, is that a part of a complex or is that an isolated single-family location?
So it's a larger multi-building apartment complex. I believe there's 3 or 4 different addresses per building. 3709 is in the middle of one of the buildings with an entry door specifically to that address on both the west or north and south entrances of the apartments. You can enter either side. Once entering, there's 4 apartments downstairs, 4 apartments upstairs.
So this specific building that you're speaking of so far has 8 apartments. Did I get that correct? 4 up and 4 down?
3709 15th does have 8 apartments, yes.
Okay. And you are focused, of course, on one apartment of those 8. Is that true?
Number 1B.
Okay. Is that location, is that overall complex, does that have a name here in Kenosha?
Yes, it's called Wood Creek Apartments.
Okay. And is that address specifically in Wood Creek Apartments, that 3709 15th Street, is that in the city and county of Kenosha?
Yes.
And in the state of Wisconsin?
Yes.
And where is 1B in relation to the other apartments in the building?
It would be the northwest apartment. So of the 8 apartments, it's on the first level northwest apartment.
So it's first level, and is it closest to the main doors that face the parking area on its side?
Yes.
Okay. And then there would be a second floor of apartments?
Correct.
So if I understand correctly, 1B would have an apartment directly above it?
Correct.
And it would have an apartment across from it?
Correct.
And then it would have an apartment on the side of it as well?
Yes. So the way yes.
When you were there that day, what can you say about the weather conditions that were being experienced?
We had received a substantial amount of rain, so everything was wet. It was gloomy, cooler.
You say substantial amount of rain. Just a short rain, a Wisconsin short rainstorm or something larger?
No, it had been days of rain.
And had that rain been going for multiple days before you arrived at the apartment on the 19th of May?
Yes.
Heavy rain?
A substantial amount of rain, very
Okay.
heavy.
Thank you. So when you got there, Detective, you arrived, there were already officers on scene. You indicate you speak to a person who identifies herself as Sadie Beacham, and she's located by her car. Is that correct?
That's correct.
Is it still raining outside in your memory?
I don't recall. I know it wasn't a downpour. If it was raining, it may have been sprinkling.
Okay. And at that point, what, if anything, did you notice about the demeanor of Sadie Beacham?
She was scared. She was visibly shaking, having a difficult time spitting out words, frightened, worried.
Could you tell what she was scared about in general?
I'm going to object speculation.
What, if anything, led you to conclusions that she was scared other than these early physical observations?
I'm going to object again as to speculation to how his conclusions that she was scared.
People don't talk the way lawyers want them to. lawyers are taught that the witnesses are to testify only to things that they perceive with their senses. I saw this, I heard this. That's not the way people converse in ordinary discourse. They combine their observations with the impressions that they personally have formed, which do often involve some degree of speculation, and sometimes involve making suppositions about what others are thinking. That's not how we talk in ordinary discourse, but when we get into the courtroom, the lawyers want to pin it down to exactly what the witness personally knows, what the witness has perceived with his own senses. But what the question is calling for is really a composite of what the detective personally observed and somewhat the conclusions, and they're suppositions as to what may have triggered the response that he was seeing with his senses. So I'm actually going to allow the answer, even though it does incorporate some of that, so long as you folks understand that there's going to be some supposition, and it can be dealt with further on cross-examination. But there will be some supposition built in, and not things that he actually has observed. So, do you understand the question? Do you remember the question?
No, I'd like it repeated, please.
So you've indicated she was shaking. You
Yes.
made a physical observation that she appeared frightened.
Yes.
Any other observations or information lead you to conclude she was frightened other than that physical observation you've testified to so far?
Yes.
And what was that?
She was concerned about her children.
I'm going to object. This answer is hearsay.
That's it's supposition.
I'd briefly like to be heard.
Well, I didn't say.
Okay.
Now, see, I'm supposing what you're thinking.
Wait,
And
I
bet
believe
I'm
you
right,
are.
too.
I believe
bet
you are.
I'm right.
Yep.
And we can have that discussion separately if and when you ask the question. But in terms of this particular question, it is not that it's hearsay, it's that it's supposition. So I'm going to sustain the objection.
All right. I'm going to head the direction you are anticipating now then, Your Honor. So, Officer, at the time that you first spoke to Sadie Beacham and she provided you information, was she physically shaking?
Yes.
And did she show signs to you that she was still experiencing emotion as she was speaking to you about what she was telling you?
Yes.
Was it, would you describe her way of expressing herself as calm or excited or distressed? What would be your explanation of the phrasing and wording and tone of her discussion with you at this stage in your contact?
She was truly scared of, petrified about what had happened.
Judge, I'm going to indicate to the court that this is an excited utterance and ask the court to allow admission of anything that was during the physical observations he's expressed.
And Judge, I would object. This witness has already testified that he was not the first individual on scene, so that there were other individuals who had spoken with Ms. Beacham prior to this. Several time had passed. Also, excited utterance has to deal with that immediate impression. Nothing was ongoing at that time. The defense would maintain that given the time that had passed and the time that had passed since she had made these observations, any subsequent statements made to Detective Anschutz, it does not fall under the excited utterance exception to the hearsay rule.
Well, let's begin. First of all, it's not my impression that they're actually being offered to prove the truth of what is asserted in the statement. I don't think the district attorney is offering this prove the content of the statement, which is asserted. Second, it's a non-testimonial statement, so we don't have that concern. To the extent that it would qualify as a here's definitionally hearsay statement, it is, I think, an excited utterance. The law with respect to excited utterances, the key is not, for example, the passage of time or the intervention of others. It's the spontaneity of the statement which is made. And given the situation that existed as portrayed in the testimony, I'm going to overrule your objection.
What did she?
I guess the couple of things, Judge, just if I may be heard. First, we haven't heard what the statement even is.
Yeah, that's correct.
And second, if the state's premising their question that they're seeking to introduce the statement under the excited utterance hearsay exception, then they must be offering it for some sort of truth, or else they wouldn't need a hearsay exception.
Well, you're right, and that's why I led off actually starting with the confrontation, or I actually started in my analysis with whether it's even subject to those rules, because it's excluded from the operation of the hearsay rule. So I would not even accept the premise that he needs an exception to get it out of the hearsay rule. But I understand your point, but I'm going to overrule the objection. Go ahead.
So my question is, what did she say to you when she was in the condition you have described?
She had told me she got to the apartment, observed the screen door closed, but the glass door opened. She looked inside, saw blood everywhere, and walked out. She said she was frightened for her children because she knew Zach Anderson had something to do with this, and
Judge, I'm going to
was
object at this point and ask that be struck.
Judge, this is all during what she said during the examination. She's going to testify. This is subject to cross-examination. The officer should be allowed to finish saying what she told him on the scene in this excited state, and not be interrupted unless there's a new objection. The court's already ruled that in that state she can say this.
Well, I've ruled that when she's in this state, she can state things that would be normally reactive to a situation in which she found herself, but now she's getting into her analysis, and there's actually another rule, which is the present mental state, purpose or plan, which probably would give some relief to the district attorney, but the problem with the testimony is it's reaching into the ultimate facts of the case, and it is relayed testimony for a witness who's available to testify, and correctly you state she's going to be subject to cross-examination, but it's not as it's her opinion about the what she's concerned about is inadmissible. It's irrelevant what she thinks.
She expresses a alarm to officers.
Yes?
I think that typically a person who has observed a crime scene is allowed to tell an officer.
I don't want to talk about typical.
Oh, okay.
Okay.
Well, so in this case, she arrives at a crime scene. She has an abundance of evidence that, of course, is not in this case so far, right? But she has an abundance of information. She is in a highly frightened condition, according to the officer, and she expresses fear for her children because of something specific. I don't think any of that's irrelevant, nor is it hearsay.
The problem is that starting with the testimonial nature of it, it's still not. But we're getting to the point where you're getting into what should come in, if it's going to come in at all, as testimonial. She's not subject at this point to cross-examination. So I'm going to sustain the objection.
After she expressed fear for her children, what happened next in relation to Sadie Beacham?
Due to her concern for the children, she
We've got to move on to the next step because he's incorporated the objectionable material into the beginning of his next answer. So just what happened next is the question.
Sadie left to check on her children.
And after that, did you then take it upon yourself to be part of an entrance into the residence?
I did.
Okay. Up until that point, what had you done in relation to the residence, if anything?
I peered in the sliding window, didn't enter, and I also walked into the hallway through the front entrance and looked around in the hallway.
I'm going to now show you what's been marked as Exhibit 1 in this case.
State's Exhibit 1, Photo 1.
State's Exhibit 1, Photo 1. It's going to come up on the screen up there. I'm going to ask you if you recognize...
Judge, I'm going to ask that it not be published for the jury before it's been admitted, that it needs to be shown to this witness first, not in front of the...
Well...
Let me talk to counsel briefly about that. Just
Okay,
so that
and I will
so that
say-
she understands at least what I'm talking about.
Okay, and based on the electronic experience we've been having this morning, it may not show up on the screen anyway.
Her objection, but she's first asking that I read a stipulation. This is a stipulation that we have previously provided the court, and it's about the admission of evidence that comes in either pictures or downloads. If I have your permission to read that stipulation to the court?
You may do so.
So this says the below signed parties stipulate. It's signed by both myself and Attorney Miller. It indicates the below signed parties stipulate that all photographs, financial records, phone records, social media records, computer downloads, and phone downloads be admitted into evidence without foundation testimony. The purpose of this stipulation is to allow all parties to discuss and question witnesses regarding these records without having to previously set a foundation. So essentially what we are doing, Judge, is we're stipulating that, you know, oftentimes in a courtroom we have to bring in somebody to say who took the photo or how was the photo compiled. You know, there's additional witnesses or additional time. We're just going to seamlessly show those records as long as we make sure each other are apprised to try to save that time, because there's an enormous amount of records and photographs, as the court is aware. Is that true, counsel?
That is true, and I just thought it was appropriate to read that stipulation prior to it being shown to the jury, so there was that understanding and the record. But any objection to it being shown now is withdrawn, now that that stipulation's been read.
Thank you. All right. Do your best.
Again, I'm going to show, Detective, I'm going to ask you to turn your attention to the television that's above the jury and look at State's Exhibit 1, Photo 1. Assuming that it works.
There it goes.
Judge, does your laser pointer work onto the television?
Doesn't work on the glass.
Okay.
But I do have.
You have the old school?
I have Sister Marcienne's. Where is it?
Oh, can you? No.
Many's the time. It's not going to come on? Oh.
Okay. Just works perfectly and seamlessly, Judge.
Yes,
Yeah.
indeed.
All right. So,
If he's going to be using the pointer, maybe we'll give him a mic. Let's hope we've got power in this.
So, Detective, as you look at this, do you recall what this is a picture of, or know this picture contemporaneous with what we've talked about, May 19th, 2020?
So this would be a picture of the north side of 3709 15th Street from the parking lot, looking at the entrance to the residence.
The residence we've talked about, apartment 1B?
Correct.
And can you tell by the conditions of the vehicles and the roadway there what the weather conditions are at the moment these pictures are being taken?
It's either raining or had rained.
Is there, do you see a white, larger vehicle that's prominent in the center of picture 1?
Yeah, should I point?
Yes.
This one?
I'm referring to that vehicle. Do you recognize that vehicle in the context of this investigation?
I do.
Okay. And what is that vehicle?
That's a white Ford Explorer, Colorado plates. That was belonged to Rosario Gutierrez.
Okay. And is that the individual who you believe to reside in apartment 1B?
Yes.
Is Rosalio's sliding doors, in other words, a non-hallway entrance to his apartment or exit to his apartment, is that visible in this picture?
Yes, it is.
And can you point out where that is located within this picture? Okay. And there appears to be a yellow sort of tape or rope that is located in this picture as well. Do you see that?
Yes, that's crime scene tape.
Okay, is that in a couple of locations in this picture?
Yes.
Can you point out again with your pointer where that is?
There's some here, stretched, and then some from the entry door to 3709, stretched out towards the parking lot.
And based on your knowledge of these investigations, who put that up? In general?
Usually the responding officers will area off so no one comes or goes.
This is after they make their initial assessment of safety and security?
Correct.
Okay. And so at the point that you have finished speaking to Sadie Beacham initially, is this the vantage point, or is this the view you are seeing back on May 19th?
Yes, that's accurate.
I'm going to show you now what's been marked as picture 2 of Exhibit 1. Do you see that picture as well and recognize that?
I do.
What is that a picture of?
So this is the main entrance to 3709. This would be the sliding screen door, glass door to apartment 1B, which is just inside the door to the right.
And do you recall whether the overall building where you see this door here, is that a locked door or is that an unlocked door to get into the main hallway?
That is unlocked door. There's also a door on the other side of the building that you can enter this hallway that is also unlocked.
Okay, so at this period of time, this apartment complex did not have locked doors into their central hallway.
Correct.
And what would you estimate is the distance from the Rosario Gutierrez sliding door that we can see there onto that small patio, and then down to a vehicle parked directly parallel below? How many feet would you say that is, or however you want to estimate the distance?
25 to 30 feet.
Okay. And much of it is grass?
Yeah, there was a small concrete stoop, and the rest grass, then sidewalk.
And of course, the concrete, the sidewalk and the patio would be probably concrete?
Yeah.
All right.
Yes.
Now I'm going to show you what's been marked as Exhibit 3. Again, is that something you recognize again from May 19th, 2020?
Yes, this is going to be the front entrance door to 3709 15th Street. This would be the sliding glass door to apartment 1B.
So it's a different vantage point, a little closer up?
Correct.
Now I'm going to show you what's been marked as Picture 4, Exhibit 1. Do you recognize where that is located on May 19th, if you do?
Yes, so when you enter that main entrance door that you just saw in the last photo, there's a stairway leading to the upper section of the apartment complex, and this would be immediately to your right underneath the stairwell. This is the door to apartment 1B.
So as I look at Picture 4, can you orient me on either direction where that front entrance hallway to the hallway is? Is it further down the hallway, or is it off to the, I guess would be the right of the exhibit?
I'm sorry.
The main doorway we saw in Exhibit 3 that takes you into the hall.
Okay.
Where's that located vis-a-vis this picture?
So this photo is taken just inside that main entrance to 3709.
Okay, so essentially this is taken in the doorway of the entrance we saw in Picture 3?
Yes.
Okay. And so how many feet, again, would you estimate it is to go from that doorway entrance to the doorway of 1B?
10 to 15 feet.
Okay. And there's a stairwell there?
Correct.
If a person wished to, could they ring the doorbell or knock on the door at 1B and be able to stand or crouch to one side or the other of that door? Is there room to do that?
Yes.
And where is there room to do that depicted on this picture, if it is?
So this is a small hallway or a small wall that extends out. If you were to go around to the other side of this, you wouldn't be seen. You also could back up to where the photo was taken and not be seen. And also there's a void here underneath the stairwell that you could stand or crouch under the stairwell and not be seen.
Are the metallic objects to the right of the door depicted on this picture, are those mailboxes?
Yes, those are the mailboxes for the 4 lower units. These are for the 4 upper units.
And based on how high up the stairwell is, if you can estimate, does a person have to sit down to be able to get to their mail, or if by bending or standing, are they able to reach their mailboxes in this picture?
Now you're able to walk up to it and get that mail.
If you know apartment 1B, does that door open, again, only if you know, does it open into the hallway or into the interior of the apartment, if you recall?
It opens in to the apartment.
So, and did it have a doorbell of some kind, if you recall?
Not in the hallway here.
Okay. So if a person knocked on this door and then did not become visible, is there one of those eye holes so that from inside you're able to see into the hallway?
Yes, there's a eye hole.
Okay. So if you kept yourself off to the side so you were not visible in the eye hole, the door opens back into the apartment if somebody is inside and they are opening the door to see who knocked. Is that correct?
Yes.
And until somebody peeked out, in other words, brought their head out of their apartment, that area by the mailboxes would not be visible to them until they somehow extended their head out into the apartment or took a severe angle after opening the door. Is that right?
I'm going to object as far as foundation, this witness's knowledge of whether that's possible and whether he attempted to do that himself.
I think he can make estimates based on his observation and how the door works. I mean, he's a physical observer. He's an eyewitness.
I think it's subject to analysis as something that he can perceive without any particular expertise beyond that of the ordinary layperson. But his description of it makes it more, makes it easier for the jury to understand. Objection's overruled.
Did you understand my question?
Go again. Sorry.
Sure. If somebody is crouching or attempting not to be seen and they're in the area of the mailboxes, okay, and they knock on the door and the person inside 1B opens that door to be able to see somebody over by the mailboxes, would they have to poke their head out?
So I would say you would have to break the threshold of the door. We train on clearing room clearing in law enforcement. And in order to see up against this wall, we have to break the threshold. That's one of our main concerns when we clear rooms before we enter them, is a blind spot up against the wall right here. We can pie the room off all we want, but we can't see this. Even if we're standing way on the other side of this door, looking on an angle, we can't see against the wall. And that's our main concern when we enter rooms, because we can see the whole room except for tight against the wall.
When you say clear a room, does that mean to try to figure out if there's danger to you in that next room?
Correct.
And would that danger include a person having a weapon?
Yes.
And do weapons include everything from guns or knives to clubs or hard objects that could hit you?
Correct.
Okay. So when you clear a room, you're worried about all of those possible threats in the possession of a person who might be crouching. Is that right?
Yes.
So did you, before you entered the rest of the apartment, were you able to make observations that concerned you at the location we're talking about? In other words, then, the door and the hallway that we're in right now. Were there observations that you, as an officer of this extended period of time, having been to scenes with blood before, did you make observations that concerned you before you entered?
Yes. I see what appeared to be blood here. That blood was running down the wall, down the door frame.
Judge, I guess I'm
On the
going to
wall.
object to his answer saying that it's blood.
He didn't say it was blood. He said it appeared to be blood.
And, you know, Judge, this is a person whose credibility on this issue is that he's been to what he told you was hundreds of crime scenes over a period of more than a decade.
We're arguing about something that's not up because I didn't.
Yep.
The witness did not say it was blood. The
Sure.
witness said it appeared to be blood. So you're safe.
Okay.
All right.
Should I go on then?
Be my guest.
Thank you.
Crouching,
Excuse me?
but I'm crouching.
Officer, did you see anything else that caused you concern at this specific location in those early observations?
Yes, there was blood, what appeared to be blood on the door. There was also what appeared to be blood on a mailbox, the wall, the door, and the mailbox.
And then ultimately, did you enter the crime scene?
I did.
And do you recall what way you entered the crime scene? We've seen two entrances, the hallway and the sliders. Which one did you go in, if you remember?
We entered through the through the sliding door.
Okay. Do you recall when you ultimately, if you know, do you recall whether this door was locked from the interior or not? Only if you recall.
Yes, this door was locked from the interior.
When you arrived at the scene?
Correct.
Okay. So when you entered, did you take any steps to try to be a steward of the evidence that was in, any evidence that might be involved in that scene?
So at the time, it was the utmost importance preserving evidence on a scene. I wore booties over the top of my shoes. I wore a mask. I wore gloves. I didn't have anything with me. I was super cautious with transferring evidence.
So when you walked in, do you recall who went in with you, if anyone?
Detective Correa.
Just to stop you, is Detective Correa the individual seated in the here at council table with us?
In the gray suit.
Okay. Who else, if anyone?
Officer Widener and Officer Van Wee.
And do Officer Widener and Van Wee have a particular reason that they would be accompanying you within the Kenosha Police Department? Are they detectives?
No, they're highly trained in processing evidence. They're specialized in that, retrieving evidence.
So let me just ask you, to the extent you know, that's a specialty in a police department?
Yes.
That requires additional training, extra training?
Large amounts of training.
And do you know, if, in your experience, are Officer, did you say Van Wee?
Yep.
And Widener, are these brand new officers who have just started the evidence collection, if you know?
No, they're both seasoned officers who've been on longer than me, 20 years. And they have been processing evidence scenes for the vast majority of their time at the police department.
Is that why they would be sent to a scene like this one, in your opinion?
Correct. They're the best we have.
Okay. So why are they, was it a surprise that they were coming in with you, or does that make sense to you in the context of what this investigation is? Describe for the jury how come there are 4 officers coming in now. We know some officers have already been in there. They have a different role. What's going on now?
So we walked in, Detective Correa and I were the investigators on the case. Van Wee and Widener were there specifically for evidence collection. So while we were in there, we communicated with each other what we've seen, thoughts on what happened, and ultimately, you know, we picked up on things, they pick up on things, and then they completely, thoroughly process the scene.
If I said that this sounds like it was a walkthrough, is that a word, a phrase that you're aware of, or a term?
Yes.
And is that what
Nothing,
you just... Go ahead.
nothing was collected at that time. We simply walked through to get an idea of what had happened there to further our investigation.
So, if I understand, it's not your role to pick up individual pieces of evidence. Is that right?
No, that would have been entirely up to Widener and Van Wee.
You're making observations to see what to do next.
Correct.
Okay. Do you observe any electronic items that are on that would at least cause you to note that in terms of, you know, why this scene would be where it is? Were there any electronic items on?
Yeah, there's a large television that had a blue screen with the name Rosario.
I'm going to show you what's been marked as Stakes Exhibit 150 and ask if you recognize that. This is, again, Exhibit 1, Your Honor, picture 150. I apologize. I'm always mean. If I say 150, I mean the picture 150.
This is the television.
Yeah, I'll continue to say it. I just keep forgetting it. Yeah. So Exhibit 1, picture 150. Does that depict what you have just described?
Yes.
All right. And so that's a television, I assume, that we see that has the blue screen?
Yes.
Okay. And you indicated it has Rosario. Can you just point that out with the pointer, please?
Yeah, it appears to be in like a standby mode.
Okay. Now, it looks like the TV screen is above a cabinet or shelving that is fairly extensive in the room. Does that appear to be an accurate depiction of what you saw on the 19th?
Yes, this was on the west wall of the living room area.
All right, and I'll show you a diagram in a minute and have you point out where on the diagram. But before I do that, is there any evidence that anything has been disturbed in this? It looks like, I mean, is this a cabinet or is this a bunch of shelving, or do you recall? If you know.
Both, I guess. I mean,
Okay.
it's cabinet with shelving, like an entertainment stand, have you?
Does it look like any items have been toppled from this or are disturbed in any kind of major way?
Not majorly disturbed. However, there were some items laying on the ground that may have been knocked off that. I don't know.
And were there any, as to this cabinet or this set of items, if you recall, did you make any observations about anything on this item? Only if you remember.
Yeah, there was blood spatter on the photos, photo frames, basically throughout.
Okay. All right. I'm going to show you.
Judge, again, I'm going to ask that be struck as far as that it was blood splatter.
There's not a foundation for the witness to identify the substance which he observed as blood. So unless I'm corrected, we're going to interpret that as it appeared to be blood.
Appeared to be blood to me.
Okay.
Judge, I just would like to approach just briefly. If we could just talk about this very briefly.
As you wish.
Okay. Officer, you just stated that an area was blood. There were some droplets there. You're not saying that you are aware that there's been some professional confirmation that it was blood. Is that correct?
That's correct. It appeared to be blood.
Okay. So when you say blood in this context, you're stating your opinion as a professional police officer based on your training and experience. Is that correct?
Correct. For now on, I'll say appeared to be blood.
But you're not saying that you did any kind of professional analysis. You're simply saying, based on what I do for a living, I'm offering you the opinion that's blood. Is that true?
Yes.
Okay. So I'm going to show you a diagram of...
He's offering the opinion that it appeared to be blood.
Yeah.
And I would add what I said before about people in ordinary discourse had some degree of supposition and personal, or not personal knowledge, but historical experience into their answers. So if he does slip into saying blood, keep in mind that is not definitively proved. It's his opinion under all the circumstances and what it appeared to him to be. He's saying it looked like blood, but when he goes back to the police station and gets back into the ordinary discourse world, he's going to say, "I saw blood in these spots." Okay? Any question about that? So there is some degree of lack of actual knowledge, and I'm gathering that this will be addressed further during the trial. So go ahead.
So now what I'm going to show you, Detective, is State's Exhibit 41, and ask you if you recognize what this not-to-scale diagram is of. This requires us to change machines, Judge, so we just need the patience of the jury. So. Can you expand out as large as you can, but still have the exhibit sticker, please? That's as far as it goes? Okay. All right. Please take a close look at Exhibit 41 for us and indicate if that appears to be a diagram of a layout, again, not to scale, that you recognize.
Yes, it's a very rough sketch of the apartment.
Does it appear to be basically accurate based on what you recall of your walkthrough at the residence at 1B?
Yes.
So on Exhibit 41, can you just point out for the jury, where is the hallway door that we saw?
It'd be right here.
Okay. And so when you enter that hallway door, what is on each side of you? So what are the first things that are on either side of you in the apartment as you enter? If you remember.
Coming through this door.
Yep. The hallway door.
So to the right, this way, would
Yep.
be, there was a couch.
Okay. And does it appear to be an L-shaped couch?
Yes, it was an L-shaped couch.
Okay. And then what else?
There was a mat
Yeah.
standing up. And then to the left was a kitchen area. But I recall there being a wall or something here.
Okay.
I'm not 100% certain.
Okay. That's what happens when you first enter, correct?
Yes.
And is there a dining room table area?
Yes, this would be the kitchen. This would be the dining room area here, dining room table.
And the rest of that then, including where the couch is the living room area?
Correct.
Okay.
This whole area would be the living room area here.
Where's the TV that we just saw located on this diagram?
Against the west wall.
Okay.
On the west wall.
And then where are those slider doors that we just saw that would bring you out by the street?
So the slider entrance is right here.
Okay. So when you entered, you said you entered the slider door, correct?
Correct.
And then if you enter that door off to the right, you see the TV that we already showed a picture of, correct?
Correct. The cabinet in the television photo that you saw would have been taken from similar to this.
All right. Okay. Now, you're not the evidence person, so I'm not asking you for specific and sort of honed in detail. But as you enter the slider doors, what is it that you observe that causes you concern, if anything?
So as soon as I walked in, I observed a substantial amount of blood right here.
And located on what?
So it would have been on the carpet, pooling of blood. So within that pooling of blood, there was an obvious void where there was no blood in the shape of a rectangle. So substantial amount of blood right here, and then a void, as if there was like a rug there that had been moved after someone was bleeding.
What else did you observe that caused you any concern?
I observed a significant amount of suspected blood on this table, on the couch, on the walls, on the ceiling, on this wall, on the cabinet, on the floor throughout here, on the back wall, and some areas in the kitchen here.
So, Detective, you sound like you're describing many locations in multiple rooms. Is that what you're intending to tell us?
There was suspected blood throughout.
Okay. And some of that's on the ground?
Yes.
And some of it on the ground is substantial?
Yes.
Okay, a lot?
Yes.
And some of it is on the walls?
Yes.
And it's not just one wall, it's several walls in the residence?
Yes.
And some of it's on the ceiling?
Yes.
And it's on the ceiling in several areas of the residence?
Yes.
What about the couch area? Did you observe any blood in that area or anything that, that in your opinion was blood?
Yeah, so the couch had like droplets of suspected blood throughout it. However, against the backrest of the couch, right about here, there was a large amount of blood up where you would put your head, up towards the top of the rear cushion of the couch. Right here.
Okay. Do you, let me ask you about some specific pictures now and just orient me as to the diagram. So you mentioned a couch and you've pointed out that's the L-shaped object, is that correct?
Yes, right here.
Okay. And then you mentioned that there was a table and a wall area that was over close to where the kitchen area starts, correct? Over sort of across from the couch. So now I'm going to show you what's been marked as State's Exhibit 155. Not 155, 55.
55?
Yeah.
State one, number.
State 1,
Yep,
55,
no, that's fine.
not
You're good.
155. So, based on your observation of the scene at 1B, do you recognize this picture as something you observed in the period on May 19th when you were in the residence late morning, early afternoon?
Yeah, that appears to be taken right as you enter through the sliding door. Yes.
Okay, so is there a door depicted in photo 55?
Yeah. This door right here would be the door that enters into the hallway.
Okay. And then you indicated there was a couch and that you recall a wall and a table. Is the wall and the table that you recall depicted in picture 55?
This wall,
Okay.
there's a small table.
Okay. And was that an area of concern for you in terms of your observations?
Yes.
Why?
There appeared to be a substantial amount of blood on it.
Then I can see some areas that appear to be staining on a carpet or rug. Do you see the areas that are depicted on this picture? Okay. Now, you indicated in your testimony there was an area on the floor that you saw a substantial amount of what, in your opinion, was blood. Is that an area depicted in Exhibit 55?
Yeah, I had mentioned a pooling of blood on the floor. This is the pooling of blood I was talking about right here.
Okay. And there are other reddish or brown stains at many locations on this carpet. Is that consistent with what you saw that day?
Yes, it was everywhere.
Okay. And do you have an opinion as to what that was in the context of everything else you saw and know from this investigation?
It appeared to be blood.
Now, you've indicated a couch, L-shaped couch. Is that depicted in picture 55?
Yes, so this is going to be the front side of that L-shaped couch with the back of it coming, I guess, out this way.
And if we go to the right side of this picture, okay, so past where the bike is, where are we in the house or the apartment at that point? Just to orient us.
So directly to the right of whoever took the photo is going to be the television stand. And then there's a hallway right here that leads down to the bathroom and bedroom.
Okay. So we haven't talked yet about the bathroom and bedroom, and that was on that diagram. It's on the other end of that apartment, correct?
Correct.
Was there anything that caused you any concern that you remember in the bathroom?
No.
How about in the bedroom?
No.
Was there only one bedroom?
Yes.
Okay. So those two areas appear to you to be untouched, as best you could tell?
Clean? Yes.
Okay. Now, I'm going to turn your attention from Exhibit 55 to number 220, picture 220. Is 220 a vantage point or a picture that you recall from the 19th of May?
Yeah, so this photo would be standing over top of the L-shaped couch with one side of the couch going this way, the other side of the couch going this way. When I mentioned what appeared to be blood on the back cushion, this is what I was talking about.
And how would you characterize that? Was that just a small amount or a substantial amount? What in your opinion, what is that?
There was a substantial amount of blood. This wasn't just a spray. It was a large amount of blood. And
then what is the object that's located on that couch that we can see sort of in the center of Exhibit 220, or Picture 220?
So that's a wallet.
Okay. And pursuant to your investigation, did you come to believe that that was Rosario Gutierrez's wallet?
Yes.
At this time, was his phone located at this time period, if you know?
No, we did not locate a phone initially.
What about his credit cards?
I don't recall.
Okay. Did you, at some point in the afternoon hours, you can go back to your desk, apologize. Did you, at some point in the afternoon hours, come into contact with another individual who arrived on the scene and appeared to know Rosario Gutierrez?
Yes.
And if you recall, about when was that?
It was about 2:30 p.m.
So you had been there almost 3 hours?
Yes.
And officers had been there for that period as well? You weren't the first there.
Right.
So when Mr. Campbell arrived, he had not been called to the scene, to your knowledge?
No.
When he arrived, did you speak to him?
Myself and Detective Correa did, correct.
And what, if anything, can you say about his demeanor when he arrived at the scene?
He was extremely worried, concerned about the welfare of Rosario.
How did he know to arrive, if you know?
Objection calls for speculation and hearsay.
Why don't you rephrase your question?
Let's see, how do I rephrase that? Pursuant to your investigation, did you come to have an idea how Michael Campbell knew to arrive at the scene?
Yes.
And what was that?
I'm going to object. It honestly calls for double hearsay,
How
Judge.
do you have an idea? It covers a lot of turf.
Yeah, it's really not for the truth of the matter. It's simply to orient how this person arrives there and sort of what happens next.
Well, if it's not for the truth of the matter, then
It's not relevant.
it's usually not relevant.
Well, when you said Mr. Campbell was highly concerned, what else can you say about what your observations were of his physical state when you saw him?
He was worried. He said that Rosario was a...
Why don't you rephrase your question? Well, we're getting into a lot of supposition, and I just think I've caught the scent of some real hearsay.
Based on the demeanor of Mr. Campbell, what happened next? So you saw him, did you ask him some questions? And I'm not asking the answers. Did you ask him some questions?
I did.
And what was your impression of his level of cooperation or forthcomingness in terms of your experience as a police officer and investigator having arrived at the scene?
My impression of Mr. Campbell was that he was concerned for a close friend of his, who he hadn't heard of from in multiple days in a row. He was concerned.
Without talking about without talking about the content of
Judge,
what...
I'm going to object and ask that the last comment be struck from the record as far as what he did, what Mr. as non-responsive, and also it calls, again, for hearsay as to what Mr. Campbell said.
It certainly, this is why I was concerned about the scent of hearsay. What the testimony that the detective has given is, the appearances of whether someone appears anxious. Those are conclusions that we all reach in our everyday lives, and that's okay. But when you encounter someone, even under these kind of circumstances, you really don't know what the person was anxious about, and if he reports what the other person said, if he's relating what was actually stated by the person, that qualifies as hearsay, generally. And then the impression that the detective has expressed, which is his conclusion from the whole incident, includes not only the hearsay, but also his own conclusion from it. And as I say, in our everyday lives, that is how thoughts are expressed, but it's not admissible in court, so I'm going to sustain the objection. And
So I just want to approach briefly again, Judge.
I'll tell you what, you'll probably be shocked that the Court of Appeals just doesn't automatically conclude that everything I do is right. They want, when there are discussions about evidence, they really want them taken down so they can see what I was thinking when I made a ruling on it. So if you want me to re-examine that issue, you're welcome to say so and why. On the record.
Yeah, so clearly one of the themes for the defense, you're asking me to do it now. if I understood the court correctly.
It was my impression, now here, I'm in the conclusion
Okay.
business too. It was my impression that you felt that the ruling was not exactly correct.
I thought I had additional information that might assist the court in terms of where I was going.
Morning break yet, did we? And I promised the jury. Let's take a break and then I'll chat with these people for a minute. Please don't talk about the case during the break.
Is it okay for me to go get some water?
Yeah. And there's some right around the corner too. For people like me who actually drink tap water, as long as it's not from New Palestine. All right, what's up?
Police neglected to do some investigating on several aspects of this case. We have Mr. Campbell arriving at the scene without explanation, and we have certainly the defense has suggested that certain other things should have been investigated. I believe that the detective would be able to provide a factual circumstance as to why he did not proceed to begin to investigate Mr. Campbell and was instead oriented in other directions. Obviously, why officers conducted themselves at each point in this investigation is of direct relevance. That was really the theme of the defense opening here. And so I'm not suggesting, Michael Campbell's testifying, right? So again, it's going to be subject to cross-examination. But what information was shared with the detective that caused the detective to have no concern about the fact that Michael Campbell had shown up at this scene, from my perspective, is relevant to describe what the motivation of the officer is or why the officer did what he did next, which is, in this case, did not believe that Michael Campbell was worthy of additional investigation or follow-up based on that moment, based on that incident. So, again, it's all about the police investigation and what motivates them to do each thing, because that's, of course, been put into direct question. Thank you.
Just because there's a defense theory or theme in place and that it may address Michael Campbell doesn't mean that the hearsay rules and the rules of evidence don't apply.
Well, I think what he's saying is that what he's seeking is not being offered to prove the truth of the matter asserted, which would make it non-hearsay.
But then why is he looking to offer it?
Because it disproves something to which you open the door.
But I don't have to prove or disprove anything. So if he's looking to use that to provide an explanation, then it might not be the truth of the matter asserted for simply that point, but it is the truth of the matter asserted for then why law enforcement did or didn't do something. And
True, but that's not the assertion. The assertion is the content of what Mr. Campbell said. That's the assertion.
I mean, at the end of the day, Judge, I guess what I'm struggling with understanding here is that if the state's going to continuously ask what another individual said, and it's true that he will be subject to cross-examination, but he's not subject to cross-examination right now. So there should be an order of witnesses that if they intend on using Mr. Campbell's statements to justify further means and ends, then they should have called Michael Campbell to the stand first and then had this officer testify. I'm not sure what rule allows the state to proceed in introducing statements of other witnesses when they are using it to establish why things weren't done. So it is being used for the truth of the matter asserted.
First off, I think that confrontation is off the table. It strikes me it's not testimonial, at least not at this point. And I think he's offering it to respond to the accusation that you've made that the police did an inadequate investigation, and not to prove the truth of what it is that Mr. Campbell claimed. And that would be true even if Mr. Campbell were not available, but if he's available for cross, then to the extent that there would be any testimonial component or hearsay component, that should be eradicated by his availability and your cross. So,
I have nothing further on the issue, Judge.
okay.
So I just wanted to tell the court that when I inartfully, I think that's the word, right?
It's a word, but I'm not sure it's appropriate.
Well, it's because I'm not far along yet. When I inartfully raised the same theory regarding the utterances of Sadie Beacham, I was doing the same thing. As the court recalls, Sadie Beacham has been specifically mentioned in the opening, and so what she said to the officer about why, for instance, the officers, what the jury knows right now is that the officers heard from her, and then they disengaged from her, and they walked in the scene. That fits right into the defense theory. You got yourself a suspect right here. What do? You say, "See you later." Of course, I'm
That was
highly paraphrasing.
heavily
but,
litigated. That can't be a suspect.
Finish.
But the point is, if you are trying to point out that officers are doing things in the wrong order, leaving things out, not doing it, then the information that they are receiving that causes them to do it. So in this case, my offer of proof is, Sadie Beacham said, "I'm terrified that my ex did this, and now I am prioritizing. I am so worried about the safety of my kids, I'm begging you to let me leave to go get my kids safe, and I'll come back." Okay, this is what she said. And so the officers let her do that, and she returns back later that afternoon with her daughter. Okay? So again, what otherwise could be depicted as, well, you got yourself a witness here, and you just let her leave, and you're not talking to her again for, X number of hours. It's explained by what the officers did, what their information is. So, again, I'm not offering it for the truth, and she is going to be back. She's, Sadie Beacham is testifying in this case. What she said to the officer and whether it's legitimate and all those will all be able to be challenged. But that information to the officer is completely relevant to why he makes the decisions he does in terms of the order things happen in this case. Thank you.
Okay.
I have nothing further on the point, Judge.
Well, I think Mr. Gravely has been premature in throwing himself on his sword because I'm just picking up on it now, so I'm the one who didn't catch it right away. And the reason is it's so commonplace for the prosecutor, and not always just the prosecutor, but usually will try to fetch a little bit of extra hearsay out of the police officers by asking for some hearsay-ish information, and then when there's an objection, say, well, it's just being used to explain why he acted as he did next. And usually the response to that, as you correctly noted, is it's irrelevant. And it is. But this time, it actually is relevant because of your opening statement. So looking at it that way, it is proper questioning.
And then I would just ask that if these questions are going to be elicited, then I want to make the record now that I would cross-examine on those statements with this officer prior to the
Well,
other individual testifying then.
The order in which he calls his witnesses, we talked about risk the other day, and we're back there, because if the witness doesn't testify, then there could be an issue, although I think I've made clear, I don't think that these are confrontation issues or hearsay issues with this understanding, and so even if the witness ultimately does not testify, I don't think it would cause any problems.
I think, though, in the situation where if they're eliciting testimony of what another witness would say for this purpose, that at the end the defense would seek a curative instruction that the jury should not consider those statements for.
There's a limit to what he's going to be allowed to draw out, and so we need to be aware of that, and I'm sure he is. And if he questions to such an extent that large amounts of information are coming out that indeed become testimonial, then that's another issue altogether. But right now, I think we're still above the level of the water. So let's take 10 minutes, and then we'll continue.
Thank you, Your Honor.
Thanks.
And those who were complaining about the room being hot, I find. You'll know. But, oh, I haven't done that yet.
Went to parochial school the whole time, Judge, so this is traumatic memories.
Yeah, he knows what I'm talking about.
Sister Cheryl, I talked about Sister Cheryl before, who's aim with an eraser.
Oh.
Candy from any angle. She could
Yes.
be a sleeper or a talker from any angle.
Yeah, absolutely. And I remember when Sister David said that she had eyes in the back of her head, and I was only 5 years old, and I believed her.
Brian, look at me trying to get down here to see. I'm like, sorry, you missed him. We're back on the record. We're back on the record.
You may be seated. Okay, thanks. I think I had sustained the objection, and after we conversed some more, I changed my mind. So the objection has been overruled.
So I'm going to return to the question, which was, what did Michael Campbell say to you regarding how he had happened to arrive at this scene at around 2:30 p.m.?
So Michael had said he was a close friend to Rosario, that they communicated regularly, and he hadn't heard from him in a couple days. They worked together, they're friends. He also stated that he spoke with an Eileen Knoll, who was also a friend of Rosario, and Rosario was doing work at her residence at the time. Eileen said that Rosario had not showed up to work at her residence multiple days in a row, and that she had not heard from him either. So he was coming to check.
Coming to Rosalio's apartment?
Correct.
And when you dealt with Mr. Campbell, how was his, as people either approach you or you approach people as an investigator, are there individuals who, when you ask them questions or are obtaining information from them, they appear to be reluctant to provide you either any information or full information about the questions you have? Do those people exist in your work?
They do, yes.
And are there also people you come across in your work who, when you ask a question, are actually trying to volunteer every fact they can think of? In fact, they're the exact opposite. They are trying to volunteer every piece of information from, again, your perspective as a professional dealing with individuals all the time.
Yes.
And if any of those are characteristic of Mr. Campbell, or if it's something else, what, if anything, can you say about Mr. Campbell's demeanor and attitude in that regard in your interaction with him at the scene?
So Mr. Campbell, when he got there, he sought us out. He was looking for us to speak to. And he provided, in a concerned fashion, the information that he gave us. I didn't feel as though he was withholding information. I don't feel as though he was hiding information. He answered all our questions. He He elaborated on all his answers to the most knowledge he had to give us. That explains my encounter with him.
Based on your interaction with him, did you feel that you had to hold him or in some way keep him in a place? Or
Judge, I'm sorry. I'm going to ask that the portion of the officer's testimony regarding and we can come up if you need, but a Hasseltine objection on the grounds of what the officer stated about.
It does sound like Hazeltine evidence.
Judge, it doesn't have to do with truth or vouching for the truth. It has to do with, again, motivating what kind of decision you can make. If one individual is in some way appears to not be providing you full information, you have one sort of course of conduct as an officer and you have to prioritize. If you have an individual where your impression, for whatever truth it is the opposite of that and you're getting all the identifying information, obviously you prioritize other investigative avenues at that time.
Arguing no.
I thought you wanted me to. I apologize.
Well, no. I'm talking about your presenting the argument that's reserved for the later part of the case, not arguing the objection. The problem is I do think it's Hazeltine evidence. It's almost a dead ringer from the social worker testifying about believing or not believing an informant. He just made a judgment.
And it's not about, it's about level of cooperation. Apologize.
Let's do it this way. The officer's testimony is that having completed his discussion with Mr. Campbell, he felt satisfied that he didn't pursue anything further with him at that point. That is, you cannot accept the officer's conclusion as accurate. I'm not saying it isn't. I'm not saying it is. That's why you're here. He made a judgment based upon his what he heard and made some conclusions from it. That doesn't mean what the truth of what was stated is. Is that clear? I'm sure I could improve on that explanation, but the point is that when we talked about Hazeltine, there was a famous case where a witness who had interviewed an accuser in a case testified that, and I think it was a social worker, testified that she thought that the accuser was being accurate in what she was telling the social worker. That's not permitted, because that is, the social worker is not allowed to decide the truth of it. That's for the jury. So we don't allow witnesses to speculate on the accuracy of statements made by others. On the other hand, people aren't in court all the time, and so they make their judgments based upon the world in which they live. And the detective exists in the world of investigating crimes and makes judgments. You refer to them as priorities. But none of that is conclusive on you folks. So to the extent that this testimony has been given, it can be considered only to on the issue of the quality of the police investigation. It may not be considered as supportive of the truth or accuracy of what Mr. Campbell stated. Any question about that? Okay, thank you. Go ahead.
Were you able to obtain identifying information on how to reach Mr. Campbell again in this case?
Yes, we got name, address, phone number. He provided everything.
And was there any difficulty at all in getting him to agree to give you that information?
No.
When Mr. Campbell talked about other people that he was engaged with and talking about, et cetera, what can you say about his level of cooperation in providing collateral numbers or ways to contact those people?
Mr. Campbell provided everything that he knew regarding phone numbers, addresses, all that. He was very forthcoming.
Based on all of the things we've talked about, did you believe it was appropriate to finish your conversation with Mr. Campbell and get back to the rest of the investigation of this case at that time?
Yes, he presented no reason to hold him or to further question at that time. He was free to leave. He left.
And I want to go back to our conversation regarding Sadie Beacham. Okay, now again, that conversation was before you went into the residence, right?
Correct. It was ultimately the first thing I did was talk to her.
Went and talked to her, and you mentioned that she was physically shaking and she appeared frightened for her children. Am I correctly summarizing that?
Yeah, she was very scared.
Okay. So one possible investigative avenue would have been to immediately take her down to the station and walk her through some more details. In other words, not just briefly have her tell you what she knew, but be very detailed about it at that first moment. That would have been a possible thing to do. Is that right?
Yes.
Were there concerns expressed by Sadie Beacham that caused you to feel that that should not be how you prioritized?
Yes.
If so, what were they?
Based on everything she had witnessed, everything that she had experienced, she felt as though her children were in danger, and she needed to get to them.
And why did she feel they were in danger in general? What was she saying to you in that initial interview that caused you to say, yeah, that's something I'm going to prioritize. I'm going to allow that to be the priority?
Because she knew, she was aware that Zach Anderson knew where the children were at that moment. So she needed to get to them and bring them somewhere where he wouldn't know where they are.
And when you say Zach Anderson, is that a person you now know in this investigation?
Yes, the defendant.
So for the purposes of our record today, when you have referred to a person named Zach Anderson, can you point out who that person is, say what they're wearing today?
He's sitting in a defendant chair in the middle with a gray suit, tan and blue tie.
Now, as Sadie Beacham was expressing her worries about the safety of her children with Zachariah Anderson, the defendant, knowing their location, was she still manifesting those physical shakings and scared things you've talked about so far?
Yes.
Based on what she told you, the content of what she said, and what you observed about her physically, did you make a decision about whether she would be allowed to take care of that priority before you interviewed her further?
Yeah, she provided where the children were, where she was taking them, and that she would be coming back as soon as that was completed.
And was there anything about her demeanor that caused you concern about her level of cooperation, such that you might feel you had to take other steps, to preserve an ability to be in touch with her?
No, she was genuinely scared.
Consequently, were you able to again interact with Sadie Beacham later that afternoon?
Yes.
And had, to your knowledge, had she been given the time to accomplish the priority she had?
Yeah, I believe she was, she left that scene after talking with her roughly 1 o'clock, 1:30ish. And I met her again at about 3:45.
Okay, now I want to now bring you back to, so everything we've talked about so far has occurred in the afternoon hours, starting at 11 a.m., but now the afternoon hours of May 19th. Is that correct?
Correct.
At some point, did you have occasion to know that the defendant had been placed in custody?
Yes.
And if you know, what jurisdiction or was it Kenosha police officers who placed him in custody, if you know?
No, it was Mequon Police Department.
And did he eventually have occasion to be in your presence?
Yes.
Where were you present with him? Were you in Mequon or in Kenosha?
He was arrested in Mequon, brought to Kenosha.
So your interaction with him was in Kenosha?
Yes.
And if I indicated that appears to have begun any interview of him occurred to have begun at 10:48 p.m. on the 19th, 10:49 p.m. on the 19th of May 2020, do you believe that to be accurate?
Yes.
And am I correct that the interview ended at approximately 12:18 a.m. on what would then be the 20th of May?
That's accurate, yes.
So if I'm doing the calculation, that is 1 hour and 29 minutes. Does that sound right?
Yes.
Okay. Did you Mirandize him? In other words, read him his rights during that interaction?
Yes, he was read as Miranda rights.
And during that interaction, how many people were involved in any questioning of the defendant?
It was myself, Detective Correa, and Mr. Anderson.
And was he in an open area or was he in an interview room? What sort of environment was he in?
So we were in the interview room, Detective Correa on one side of the table, Mr. Anderson on the other side of the table, and I was sitting in between.
And at the point that you came in contact with him, had you received guidance as to what the defendant was aware of about any circumstances regarding Rosario Gutierrez? In other words, had you been made aware that he had some knowledge of some subject matter as you began to speak to him?
Yes, it was my understanding Mequon PD had informed him why they took him into custody, and he knew why he was coming to talk with us.
And so do you believe he had an awareness based on the information you were provided that an individual named Rosario Gutierrez had disappeared?
Yes.
So you believe he knew that at 10:49 p.m. on the 19th of May?
I'm going to object as far as speculation as to what he believed Mr. Anderson knew.
Well, Judge,
And if it's not speculation, then there's been a lack of foundation.
Again, it goes to what the officer did at what point in time.
If I may respond to that, Judge?
Go ahead.
Thank you. This isn't getting to why the officer did something, or this is getting into statements of Mr. Anderson and what Mr. Anderson believed to be or not to be. I think we need to make a clear distinction between the other witnesses.
Well, this is it's similar to the other witnesses, but this is a huge amount of speculation, and it's explanatory only on the issue of why the police acted as they did, which in and of itself is only is usually not an issue that we examine in any depth. There is, however, a claim in this case, which has been made by the defense, that the police did a inadequate investigation. And so to some extent we're scrutinizing, well, you're scrutinizing the adequacy of the investigation in terms of the ultimate issue for you, which is the pursuit of the truth of this incident. His conclusion from what he heard from the defendant is totally insufficient to establish what the defendant was thinking. and is explanatory only of why he acted as he did in furtherance of the investigation. So I'm going to let the question be answered, but you must understand that under no circumstances are his conclusions legally adequate to base a verdict as to the truth of anything in our strictly for explanation of course of the police investigation. Is that clear? Okay, thank you. Go ahead.
And because of the hour, I'm going to move on to another topic, and at some other time, I'm going to come back to the interview, just because I don't want to chop that up. If,
Would you wish?
So I'm just explaining to the court why I'm changing topics after the court ruled. Detective, did the Kenosha Police Department do some searching at a residence that they believed was owned and occupied by the defendant on May 19th, 2020?
Yes.
And was that address 6813 West Highland Road in the Mequon area?
Yes.
And on the 19th of May, were you in any way involved in that search?
No, I didn't partake in any searches there that day.
And was that partly because you instead were involved in interviewing the defendant?
Correct.
Okay. On the 20th of May, were you part of a return to that address at 6813 West Highland Road to check out additional areas and to do additional search for evidence?
Yes.
And was that during the daylight hours?
Yes.
And you hoped that being there during the daylight hours, I assume, would assist you in searching the property. Is that correct?
Correct.
Okay. Do you recall in general, can you in general describe that property? In other words, how do you get there? How do you get in there? And what in general do we have that you needed to look at?
Yeah, so it was a gravel driveway entering the property. There was a house and several outbuildings, including a couple garages, a couple old chicken coop areas, a couple lean-to parking areas, some sheds, and I remember there being a camper parked on the property as well.
And when you got there on the 20th, did you observe vehicles that were of some interest to you at that time?
Yes, there was a black Audi sedan and a black Chrysler minivan.
And had those vehicles in some fashion come up in your interview with the defendant on the 19th?
Yes.
I'm going to show you now what's been marked as State's Exhibit 1, Photo 254. Just ask you briefly if you recognize that item from your search of that Mequon area residence on May 20th.
Yes, that's the black Chrysler minivan that I saw at the residence.
And did that vehicle appear to be owned by the defendant, if you know?
I don't recall.
Okay. Then at some point, first of all, did you actually search that vehicle, or did you just observe the interior of that vehicle?
So I looked in the side and rear windows of the van. I never went inside.
And what could you, in general, observe from the inside of that van?
Observed a container of Clorox bleach wipes, an opened box of garbage bags in the back. I observed that the rear seats were out of the minivan. I also observed that there was a large piece of carpeting removed from the back, about third of the carpeting in the back area had been roughly cut out. And the carpet that remained had several white blotches on it that appeared to be like a bleach stain.
I'm going to show you now. I'm going to show you now what's been marked as Exhibit 1, Photo 263. Is that a vantage point or a view that you believe you observed in the context of May 20th, 2020?
So that's with the tailgate up, the lift gate up on the back. But yeah, I was peering through the window of the van, and that's what I observed.
This is the vantage point. Essentially, this is from the back, but this is what you saw when you looked inside?
Yes.
So if you could take, if the court would indulge us and let you have that pointer again, then I'd ask you to approach and first point out to me where the items that appear to you to be bleach stained.
I don't need to talk.
Where's the area that you felt appeared to be bleach stains?
This little area here, there's some here, the white off-colored.
Okay. And then the area that you said was about, I think you said about a third that was rough cut. Is that area depicted in this? And if so, can you just point that out in general?
You're inquiring about the area that was cut out, correct?
Yeah, if you could just point that out for the jury. Where is the area?
This whole third back section.
And does that area include exposed wires?
It does.
Okay. And exposed sort of bottom of the vehicle because the carpet's out?
Correct. This didn't appear like a factory, like how it comes, because the under insulation area here was kind of sticking out, and you know, a factory cut would be nice and clean. This was not clean cut.
Now, did you do anything further with the van, having made these observations yourself?
That day?
Yes.
No.
Okay. Was the van retained as evidence so that other decisions could be made about the van based on the observations at a later date?
Yes, it was secured and decided that we would take the van.
Okay. From that Highland Road address?
Correct.
And where did it go to, if you know? Only if you know.
The Wisconsin State Crime Lab.
Okay. And what is the Wisconsin State Crime Lab a place that analyzes things like this van, if you know?
Yes.
You can sit back in your chair. And so would that be the logical place you would send it for a more thorough investigation than the Kenosha Police Department is able to do?
Yes. State Crime Lab's probably the would do the most thorough job of processing evidence.
I'm going to now ask that you take a look at Exhibit 1, Picture 271. Is that a vehicle or a vantage point you recognize from the residence?
Yes, that was the Audi sedan that was parked in the driveway.
Had this also come up in the interview?
Yes.
All right. And so that was also at his residence on the 20th when you arrived?
Yes.
Did you have an opportunity to search the house itself?
Yes, I went through it.
Do you recall how much land we're talking about here?
I believe it's 4 acres.
And did you have an opportunity to search the outbuildings that you described?
Some of them, yes. I personally, some of them.
Did you have a crew of people with you that day?
Yes.
Do you believe that, and was it Kenosha Police Department?
Yes.
Do you believe that all the buildings were searched on the 19th and the 20th?
Yes.
And were the grounds searched as well?
Yes.
Was there anything of note or interest to you, knowing that you've talked about the weather conditions over the last few days before and the heavy rain? Was there any anything of note in the outdoor area that was of any interest to you, particularly knowing that it had been raining?
Yes, there was a larger sized fire pit that was smoldering directly behind the residence in a grassy area.
And can we see that general area in this picture or not really?
Just here, I can point.
Yeah, if it's partially depicted. Okay. All right, you can go back. And you said that was still smoldering?
Yes.
And that, what does that mean to you? How were you able to tell it was smoldering?
It appeared the ash in the fire was still burning and creating a smoke from it.
And was it? It looks fairly sunny at the moment you're there on the 20th. Is that at least based on that picture? Were there moments of sunshine on the 20th, that you know of? It's not the 19th. It's the day after, the 20th.
Yes.
Okay. At some point, did you also find that there was a dumpster at the residence?
Yes, it's in that picture right there.
Okay. Is it a blue object in the picture?
Yes.
Were the contents of that emptied and looked through?
Yes, we actually had a dump truck or a loader come and dump the contents out in the driveway.
And was there garbage either in the house or attached to the house in some fashion, connected with the house? Garbage bags, garbage cans?
In the dumpster?
Okay. What about in the home?
Yes.
Okay. Was that garbage searched?
Yes.
And was there a trailer located at this home?
Yes, camper.
And did it have debris?
Yes, there was a trailer. There was also a camper trailer.
Okay. So, I'm sorry. Okay, so there was a trailer like that somebody would use as a residence or a place they might park at a campground or something?
Yes.
Okay. Was that searched?
Yes.
Okay. Was there also a trailer that someone pulls to move items around?
Yes, it had. It was a sided trailer with some furniture and like lath and other construction stuff, I guess. Yeah.
Where was that located at the residence in general?
Next to the dumpster.
Okay. And in that, were the contents of that trailer that we've just talked about also looked at in this case?
Yes, it was thoroughly searched.
Okay. I'm going to show you what's been marked as State's Exhibit 1, picture 274. Is that the trailer we've talked about?
Yes.
Before it was looked at item by item?
Yes.
Now I'm going to show you what's been marked as Exhibit 1, page 275. Is that the same trailer?
Yes.
Is that a vantage point of the trailer that is a way shot of some tools that were located in that trailer?
Yes.
And again, is this before the vehicle itself or the trailer itself was looked at item by item?
Yes.
And then I'm going to show you what's been marked as photo number 276 in Exhibit 1. Is that a close-up of tools located on the defendant's property at Highland Road in that trailer?
2 hammers and a knife.
2 hammers and a knife, and the knife is in a sheath of some kind?
Correct.
And are these all true and accurate pictures? In other words, that's what you remember from the date of?
Yes.
So at some point, did you come to believe that persons who you could identify who had last seen the defendant described him as wearing a flannel shirt?
I'm going to object as far as hearsay. That is being used for the truth of the matter asserted.
It only goes to, again, these are people who are going to testify. It goes to why he would search for this particular item. You know, he's doing a search. It only explains why this item would be an item he is searching for. You recall a flannel shirt being brought up by witnesses saying when they when they last saw the defendant, he was wearing a flannel shirt of a certain type.
Yes.
And were you provided a picture of that flannel shirt?
Yes, I was.
So you knew precisely what sort of shirt and what you were looking for when you did this search warrant on the 19th and the 20th, weren't you?
Yes.
You weren't there the 19th, but on the 20th you were.
On the day of the 20th, I was, one of the key things I was looking for was that flannel shirt.
Okay. So I'm going to show you what's been marked as State's Exhibit 42.
Like 40, sorry.
So is that a picture provided you by witnesses so you knew what shirt to look for?
Yes, what you see is significantly blurrier than the photo that I have. It was a lot clearer, the one I looked at.
But it does depict the same shirt.
Yes,
Okay. And so you looked for that shirt
I did.
at Highland Road.
Yes.
Did you, was that shirt found in any of the buildings that we've talked about?
I was unable to locate that shirt.
Was it found in any of the garbages that you looked at?
No.
Was it found in any location on that property in any way, shape, or form?
No.
Having seen that a third of the van carpeting of a van on the property appeared to have been not industrially cut out, did that become something you were interested in?
Absolutely.
And so as you searched all of the areas we've talked about, did you look for this van carpeting so that you'd be able to account for it and see if it had any evidentiary value?
Yes.
And did you find that in any part of this property or location?
No.
Were you, had you spoken to witnesses who indicated that they had seen brand new duct tape and brand new rope at the residence just on the day that Rosario Gutierrez disappeared? Were you told that on that same day, earlier in the day, duct tape and rope had been present at the residence?
Yes.
That was new.
What's that?
That the person believed was new.
Correct. Brand new in packaging.
And did you attempt to search for those items
I
at
did.
the residence?
I
And
did.
Were those items anywhere located at the residence?
No.
Judge, based on me finishing that topic and the next topic being a fairly significant one, I would suggest this is the ideal time to break for lunch.
No problem with that, Judge.
Any problem with that? Let's take a break, and let me ask that you return at 1:15. Is that convenient? Okay, please don't read, watch, or listen to any account of the trial. And any questions? Thank you.
ask about in this next section, which is the defendant being interviewed by officers. I'd like the defense to have an opportunity to weigh in, and to the extent the court is comfortable, to give me guidance on how to approach this, if at all. Can I do that briefly?
Yeah.
Okay. So I intend to ask about the contents of the hour and 29 minute interview that occurred between the defendant and the two detectives. I would like to be able to ask the detective whether there were additional questions that the detective did not have the opportunity to ask during that interview.
And,
Let me finish. I'm almost done.
Sorry.
And then also, were there any other opportunities to interview the defendant? So I don't intend to go any further than that, but again, we're talking about this avenue of what was the investigation. Certainly an hour and 29 minute video or interview does not, as the court is well aware from its long experience, is not an amount of time to cover all topics that would be necessary. I don't intend to go any further with it, but I believe that is the line, and I'm asking the court if I have permission to go that far and no further.
Go ahead.
thank you, Judge. Asking why there were other questions that should have been asked that weren't, and then that they weren't able to have the opportunity to question him again is encroaching on the fact that my client asked for a lawyer, and that was why the interrogation concluded. So asking those questions, implying that there's more and that my client chose not to speak, is directly going towards his right to remain silent at that point. So I would argue that the state cannot ask those questions of, oh, would you have asked more questions if you would be able to? Because the inference there is that they weren't able to because he invoked his rights, and that they didn't get to talk to him again because he invoked his right to silence.
And again, I only bring this up because of the issue of the adequacy of the investigation, right? So there are natural limitations. I'm aware I cannot go any further, so counsel indicated, what I can't argue, and I absolutely agree. I can't say here's why or in any way imply that in argument or in question. But I do think it's a proper question right at the line. It's a proper question to ask as I described to the court.
Well, the problem is you're lobbing the ball over into their court and saying, did you have an opportunity to ask more questions?
As you often are when you go to the line. Right? I mean, that's the nature of it.
But we don't want to do anything brazen.
Right.
You're lobbing the ball onto their side and making them respond. And they're kind of handcuffed if the answer is he lawyered up. And of course, then you're in the forbidden woods.
Right. So really the analysis, though, is am I asking a question that comments on his silence or comments on his invocation, right? So the court is right. It has some consequences, but the question is the question one where I am calling on the officer to indicate in some fashion that he has invoked his right to silence or to an attorney? I would suggest to you, as suggested, the question does not do that. Of course, I can't argue. I apologize.
So, yeah, a very, very tight interpretation. You could make that claim, but the problem, as I say, is you're forcing the defense into a position where it has to come up with an answer, and if the answer is that he had talked to a lawyer and whether he talked to a lawyer or not, he simply decided not to discuss anything further with the police, they can't respond, and so it's sitting out there, and if during the remainder of the testimony a juror is thinking, after hearing the remainder of the testimony, a juror is thinking, all these years since this and the defendants never told the police anything more, then you're definitely, what is the name of the case? I think it's Champlain Chambers, one of those.
Oh.
Not one of those, well, whatever it is, the rule is very clear that there's no comment permitted by the prosecution on the failure of the defendant to address the case.
That's a bright line rule, and I'm aware of that.
Okay.
Now, what has happened is the defense has lobbed into the states. I mean, let's be sure we talk about this fully in the venting of what you described. There's been an opening statement. It is certainly said detectives made a number of poor choices here, right? I mean, that is the clear thing, right? So a reasonable juror hearing the 25, perhaps 30 questions that officers did ask would very reasonably, based on the argument made and the ball being lobbed into our court, say, well, why the heck didn't the officers ever address with the defendant why this van is cut out, a third cut out, or any other thing that the state suggests is of significance here? Why wasn't that ever brought up to the defendant? That sounds like it's the same pattern of they didn't test fingerprints at X, Y, and Z. They didn't search this part of the woods. And we're left with no way to respond because, in fact, those questions would have been asked or certainly could have been asked had there been a different posture. Now, again, I am absolutely conscious. I am not allowed to bring up an invocation of either silence or the right to an attorney. But I think that the simple declaration by the detectives that they would have asked that they would have liked to ask additional questions and that they never had an opportunity settles the matter. It creates a situation where the prosecution is not going to be penalized based on the argument made by the defense for any question that the juror wishes a detective would have asked the defendant. I mean, otherwise I'm left without an explanation, right? Because the explanation is a legal and constitutional one. So I'm tied. If the court says I can't even reach that line, I have no way to respond to a juror concerned that in the context of what's been said, what the heck, why wouldn't a detective ask that question? He asked 25 others.
First, about the ball being put back in their court. The ball's in their court. They have the burden. It's never that we've shifted that burden here. And second, as far as the answer to a question of why weren't you able to answer these questions that you would have, the only answer that a detective or any witness can give is that we weren't able to continue questioning because he invoked his Miranda rights. So there's no leeway here. It's not the defense's fault if the state doesn't have any other evidence to support its claims. It's their job. The case that deals with this issue is Griffin versus California. It's 380 U.S. 609. And in that case, and I'm just going to read, it says that a comment to the jury by a prosecutor in a state criminal trial upon a defendant's failure to testify as to the matters which he can reasonably be expected to deny or explain because of facts within his knowledge or by the court that the defendant's silence under those circumstances evidences guilt violates the self-incrimination clause of the Fifth Amendment of the Federal Constitution as made applicable to the states by the 14th. There is, and also this concept that I'm going to ask an officer, well, why didn't you ask my client that? Well, obviously, I'm not going to violate my own client's constitutional rights. I would not ask a question of that sort. The questions that the state have outlined are clearly across the line of what's permissible under a constitutional lens and pursuant to Griffin versus California and my client's Fifth Amendment rights.
The case does not stand for the proposition that I can't reach this place that I am. I've been very careful in the litigation here. I've approached the court first. I'm doing the exact opposite of commenting on the defendant's silence. I'm asking the court for guidance on how I can structure a question to a detective that allows there to be no comment on silence, but also allows a fair presentation of this evidence to a jury in the way I've described. Again, the only other option we're left with is a jury wishing there were answers to other questions, knowing a series of questions have been asked, and left with the implication that officers are not competent enough or not, you know, or not, or are too lazy to ask these additional questions. Now, again, I don't mean to comment on either of the two things. I simply ask the very structured questions. I believe I'm doing it in the appropriate way. It's the exact opposite of the case cited where a prosecutor actually comments on this. I am trying to be careful in my litigation here and ask the court for guidance to be able to ask those two questions. Did you ever get a chance after the interview on so forth? Did you ever question the defendant again? And then the second one is, were there other questions that you would have desired to ask based on your investigation? Period.
Yeah, and of course you did the right thing by bringing it up first.
Sure.
But you know, to the extent that you ask me for guidance as to what you can do, that I can't do. I can't give you advice as to how to
Well, I've told you
present
this.
your case, and I've made it pretty clear what you can't do.
But I've told you the two specific questions I intend to ask, so I think the court can probably help me with that.
Well, definitely the second one is totally out. What was the first one?
The second one is, did you have any other opportunities to speak to the defendant?
No, that's
Okay.
that's
So
gonna
the
take-
first one was, are there other questions that you desired to ask of the defendant that you did not ask?
Yeah. You know, the fact that you're complaining that you're left without a way to somehow effectively cover this, that sometimes that happens. And sometimes it happens because of the Constitution. But it's what it is. You know, and I don't know if you know, can you cover something like that in your argument to the jury and say,
I imagine that is more problematic.
I didn't tell you what I was going to do to raise your hair.
Apologize.
Or those events. And I think I'm actually going to stop and not do it, but there's at least one way I can think of that I would at least be tempted to do. And well, I'll leave it at that. I don't think you're without a way to buttress the police investigation. But the way that you're explaining it to me is not one that I think is one that I would sanction or even permit.
Okay.
No.
Okay, thank you.
Okay.
Do we have any prior record that we have to work out? It doesn't have to be now.
Okay. Ready to go? Okay. Were there late jurors or?
No.
Everybody was here on time, but it just took a long time to go.
Hello.
Would you come down, please?
Yep.
John Anthony Ward, what's going on? You have a divorce trial when? When? Well, another state is 9 miles away. Enjoy the day. No, I haven't checked the weather forecast. Are they still talking all kinds of ominous weather this afternoon, or is Oh, it's tomorrow? Okay.
For Kenosha, they were wavering somewhere between 1 and 5. Yep.
I thought there was a chance it was all going to be rain here.
They started approaching, and then they said it's worse south of us, but with the slightest change in wind. Meteorologists are my favorite.
Well, you're being too harsh there. They've correctly predicted 45 of the last 3 snowstorms.
Judge, currently the Weather Channel is saying snowfall around 1 inch, for whatever that's worth.
Hey, this is Wisconsin. Huh, I won't even notice. All right, Mr. Gravely.
Thank you, Your Honor. Detective, when last we were here, I was about to again begin to ask you about the interview that occurred on May 19th, 2020, regarding the Zachariah Anderson. And again, you've identified Zachariah Anderson as the individual here in this courtroom. Is that correct?
Correct.
And you spoke to him for about an hour and 29 minutes in total,
Yes.
and that was a question and answer format.
Yes.
And did it include the defendant also asking some questions during some of that period?
Yes, he had some.
And did you provide him any nourishment, any food or water?
We gave him water, which he requested a couple of times.
And ultimately, that interview then concluded, if I got this correct, at 12:18 a.m. Does that sound right?
Yes.
Okay. So in the time period of that interview, did you provide any threats or promises to the defendant to get him to provide any information?
No.
Did he provide that information? Did he answer some of the questions you asked at least?
Yes.
All right. And did you at some point have occasion to talk about a phone that purportedly appeared to have ended up in a car driven by his ex-girlfriend, Sadie Beacham?
Yes, I did.
And was this something that you asked him about?
Yes.
And what do you recall him telling you about whether he had intentionally placed that phone or some other explanation?
So Zach had said, Mr. Anderson said that Ms. Beacham had dropped the kids off at his residence, and during the course of taking his son out of the back seat, he believed that this cell phone may have fallen out of his pocket, or his son may have grabbed the phone and put it in the car.
What, if anything, did he say about whether he, on purpose, hid that phone under the car seat?
No, he said he didn't realize this until after Sadie had left and he realized the phone was gone.
What, if anything, did the defendant say about how he managed to figure out where that phone was then located after it was in Sadie Beacham's car in that location?
Mr. Anderson said he contacted the phone provider, Cricket, and Cricket told him that the phone pinged in North Kenosha.
What, if anything, did the defendant tell you about having loaded an app on his electronics that would, in fact, trace the exact location of that phone prior to losing the phone? What, if anything, did he tell you about that?
He said nothing about it.
What, if anything, did he offer to you regarding indicating that on the date that Sadie discovered that phone, that he actually had accessed that app to be able to discover where the phone was using the app in his own electronics? Did he mention any of that to you?
He said nothing to that.
Did you ask what, if anything, did you ask the defendant about having been to Sadie's home during the early morning hours over the last few weeks? Did you ask him that question?
Yes, I asked him if he had been to Ms. Beacham's house at any point during the early morning hours.
Let me just stop you for a second. And did they live together at that time?
No.
And per your investigation, was he welcome at that house in the early morning hours?
No.
Okay. So when you asked him that question, it was a specific question about in that context. Is that true?
True.
And what did he first offer up to you as his explanation for for a visit to her home in the early morning hours? What was his first explanation?
He said there was a time when he had picked up a couch late one night and he was dropping the couch off there late.
Go ahead. And did you then repeat the question, ask him again, and ask if he had his kids along on any occasion? Did you ask him that?
Yes, I asked him if there was another time when he had his children that he went there.
And then did he offer that he had?
Yes.
Could he remember the date? As best you remember?
No.
And which children did he claim he had taken along with him?
All three of his children.
Okay, so he has a couple of twins who are younger, and then a daughter who's, 10, 11, 12, something like that?
Correct. He said he had taken his daughter as well as the two twin boys.
Was it at night?
Yes.
Did he indicate why he felt a need to take his children? He had the children with him, is that what you're saying?
Yes.
So why did he indicate he felt he had a need to take his children when Sadie Beacham would have not been caring for the children?
So he, first he said there was a car in the driveway, and then he stated he had a premonition that there was someone at her house.
And at that point, were these two in a marriage, as far as you know?
No.
Were they in a situation where any of the children would be at Sadie's home?
No.
Okay, so he and the children drive to her home per his report? Is that right?
Correct.
And at what does he indicate happens when he is at that residence?
So he said when he pulls in the driveway, there's a vehicle there with Colorado license plates.
And let me stop you. Does Rosario Gutierrez have Colorado license plates on his vehicle that you saw at his residence when you discovered he was gone?
Yes, he's a white Ford Explorer with Colorado license plates.
Okay, so what else did he say?
He said he got out of the vehicle and looked through a window.
Look through a window through a window at the vehicle?
Looked through a window at the house.
Okay, and whose home is he speaking of?
Sadie Beacham.
Did he say he saw some things inside?
Yes, he said he saw them on the couch.
Okay. And did he indicate whether any of the children were also involved in looking in the windows?
Yes, he said his daughter also came out of the car and looked through the window.
And did he indicate that he had that was something he was a part of in some fashion?
He had told me his daughter did this because she wanted to.
And did you at some point ask the defendant whether he recorded any using any devices of his at Sadie's residence when he and his daughter were there looking in windows?
Yes, he denied recording anything, although he did admit to having a cell phone in his possession at the time, but that he used the light on because it was dark.
And was it his regular cell phone?
I'm going to object as far as foundation.
Did he? I'll ask again. I'll clarify. Yeah. Did the defendant explain to you that he had more than one phone that he was using on a fairly regular basis?
Yes.
Okay. And did he describe one as his primary phone and another as his secondary phone?
I guess, Judge, I've been lenient, but all these questions have been extremely leading. So I'm going to object to leading and ask, and then it not be leading.
And I apologize. I was just doing it in this situation. I was just doing it because it was a foundational question. So, but
It's just been like 5 minutes of foundational questions then.
That they are tending towards being suggestive, so if you can rephrase.
what do you recall about whatever he told you about these phones?
He had two phones, one he used primarily for calling.
And what, if anything, did he say about doing any recording using any devices on this particular date?
He did nothing. No recordings.
At some point, did you begin to ask questions regarding a new boyfriend of Sadie's?
I did.
And what, if anything, was the defendant's discussion with you when you first brought up this individual in terms of things like whether he knew his name, a general discussion of what he appeared to know about this new boyfriend?
He said he found out about the new boyfriend through his daughter, as well as a grandmother. Grandmother had shown daughter a Facebook profile of this subject, and that's how he found out who he was. I asked him what his name was, and Mr. Anderson said I believed it was Junior, and that his last name started with a G, and that he was a Mexican.
And what, if anything, did the defendant ever tell you about the fact that in his own phone he had, well, let me stop. Okay, so did the defendant ever reveal to you that he actually did know the full name of the individual that Sadie was dating? Did he ever tell you, yeah, I know the guy's name?
No.
Now, at some point, did you begin to focus on the vehicle that the defendant may have driven at various times that you were interested in?
Yes.
And what vehicle specifically were you interested in regards to your interview with him?
I asked him about the Chrysler minivan that was parked in his driveway.
And what do you recall about the defendant's response when you first suggested anything to the effect that he was a driver of the van?
He described the minivan as either being black or blue or something, and that was his words. He also indicated that he doesn't drive it much. And that it's basically there for the taking.
Did he describe to you that he drove a different vehicle, if you know?
Yeah, the Audi. He mentioned the Audi.
Okay. And what, if anything, did he say about whether he had ever been in Kenosha at a time that Sadie had been there?
He said he couldn't remember the last time he was in Kenosha.
Period?
Period.
Okay.
He did mention that he plays board games with his brother, and they may have been in Kenosha. But he didn't recall ever being in the city of Kenosha.
And in connection with being there because Sadie was there, what, if anything, did he tell you about that?
I'm sorry, repeat that?
Yeah, did he indicate that he ever followed Sadie down here to Kenosha?
No.
At some point, did you direct your questioning to whether anything had ever been taken from Rosario Gutierrez's vehicle, that truck?
Yes.
And what, if anything, did the defendant tell you about whether he had taken any items from the vehicle of Rosario Gutierrez?
He told me to spare the accusations. He's already been accused of this, and that it didn't happen.
And what, if anything, did the defendant offer to you that in one of his phones there is a screenshot of, in fact, a registration document regarding that truck?
Nothing.
What, if anything, did the defendant say to you regarding whether he had any jealousy towards the fact that Sadie had a new relationship?
He had admitted to me that he did have some jealousy. However, spun that and said that Sadie was the one that was jealous of him.
And did you, what if anything, did you ask whether these two individuals, meaning the defendant and Rosario, whether he had ever seen Rosario?
I did. I asked him how many times he had seen the subject he was referring to, and he had told me it was just the one time when he peered into that window.
So what, if anything, did the defendant offer you about about his phone being in Kenosha on May 13th, which would be a different time than the time that you are speaking of? What, if anything, did he offer about that?
Nothing.
What, if anything, did he offer to you regarding the idea that he was texting Sadie, directly quoting things that Rosario was telling Sadie in Rosalio's residence on May 13th in Kenosha?
He said nothing.
So as to May 13th in Kenosha, what, if anything, did the defendant say at all about that in the context of perhaps being a second time he had seen Mr. Gutierrez?
It was never mentioned.
At some point, did you bring up an individual named Steve Lentz, or did the defendant bring up a person named Stephen Lentz to you?
Yes.
And just so we understand, who is Stephen Lentz in this investigation, if you can tell us?
Stephen Lentz was identified as a friend of Mr. Anderson, a neighbor. At one point, Mr. Lentz actually lived in his backyard in a tent at one point. Mr. Lentz's mother lives right down the street from Ms. Beacham, about 400 feet down the road on the opposite side of the street.
From where Mr. Lentz, and was Mr. Lentz residing there in April and May of 2020?
Yes, he was.
And from Mr. Lentz's then residence, could you see any portion of the house or a place where Sadie Beacham was living?
Yes, you could see the driveway of Ms. Beacham's residence.
And were you able at some point to obtain a phone number from Stephen Lentz?
I did.
And just for purposes of us clarifying, was that phone number based on the records that you reviewed, et cetera, 414-378-4935?
Yes, I believe so.
Okay. So let's go back to the interview with the defendant. At some point, Stephen Lentz came up. What do you recall about how he came up?
We went back to the idea that he had a premonition someone was at the house. Ultimately, Mr. Anderson told me that there was a guy named Stephen Lentz that would call him and tell him when vehicles are in the driveway. But he also stated that he had never told Mr. Lentz to provide this information.
And what, if anything, did the defendant ever tell you about communicating with Stephen Lentz, asking him on occasion if there were cars in Sadie's driveway?
Nothing.
Now, when you spoke to the defendant, what were you telling him that you were questioning him regarding?
I told him we were investigating the stalking incident.
Did you tell him who the people were who you were suggesting he might have been stalking?
Yes.
Okay. He had been arrested. Did you were you having this discussion with him? So, if I understand correctly, there was a contact with law enforcement, and he got arrested in Mequon.
Correct.
And then, about how long after that arrest in Mequon do you estimate it was before you're having a conversation with him about stalking Sadie and this other individual?
I don't know the exact amount of time, but Probably 3 or 4 hours later.
Okay. And at some point, did you focus on attempting to figure out where the defendant had been on the day of May 17th, 2020?
Yes.
Okay. And if you can briefly say, why was that your focus, as opposed to the 16th of May or the 23rd? You know, what was the reason why you were focused on the 17th of May in your questioning of the defendant at that moment?
From what we knew at the time, that was the last communication with Rosario, was on the 17th, and we believed that that was the day that the incident occurred, from what we knew at that point.
And did you believe that also to be in the evening hours?
Yes.
Okay. So you had a general amount of time that you were focused on because that's where your investigation was at that moment.
Correct.
So do you remember focusing on that with the defendant, where you asked him, you know, so please tell me about what was happening on the 17th of May?
Yes.
Okay. And again, you're on the 19th of May now?
2 days later, yes.
So you're asking him on a Tuesday what happened on that Sunday during the day. Is that correct?
Yes, day and night.
Okay.
Yep.
And so what do you recall about what he offered to you first in terms of his activities on Sunday?
So he said he was with the children during the day, and Sadie came to pick them up.
Did he tell you in general when that occurred? In general?
I don't recall.
Okay.
I wanted him to keep going with the rest of the remainder of the evening, and he said he thinks he went to a girlfriend's house named Christine.
Okay. Did he eventually offer the last name of that girlfriend as well?
Yeah, Christine Remsburg.
Okay. And did he indicate that when he went there that he believed he had spent the night? Was that his initial discussion with you?
He was very wishy-washy on what he did that night. He said he may have been there, he may have stayed the night. Wasn't really sure. Yeah.
And did that wishy-washiness come when you pressed him and said, dude, you don't remember what happened 2 days ago? Is that when that happened?
Yeah, I was unable to get anything concrete as far as what he did that night, and he was just throwing out things. First he said he stayed with her, then he said he may have called her, he doesn't remember. He just never gave me an answer.
What, if anything, did the defendant say about ever having an in-person interaction with this person, Rosario Gutierrez? Did he offer any, what, if anything, did he offer in regards to that?
Nothing. He said he only saw him that one time, which was through the window.
What, if anything, do you recall about the defendant offering up something about Sadie and her having a nice jacket and what that meant? Do you remember what that was about, if anything?
He said Sadie dropped the kids off at one night, and she was bubbly. Called him Zachariah, and said that she had a nice jacket in the back of the car, and suspected that she was going down to Kenosha to visit Junior because she had that nice jacket in her possession.
this witness. Thank you.
Yes, thank you, Judge. Detective, I'm just going to start off with some follow-up on this interview that you had with Mr. Anderson, since that was just the last thing you talked about.
Sure.
You had testified just now that you had asked him about taking the registration from his truck, correct?
Yes.
And his exact response was, I don't have his registration card for his truck.
No, he said, spare me the accusations. That was the first thing he said. And then I didn't take it.
If I was to show you a transcript of that interview, would that help refresh your recollection?
Sure.
If I may approach the witness, Judge,
So do you have a copy for me?
I can show it to you.
Copy of it. If you're going to use a transcript and use it as a source.
I can show you what I'm going to show him to refresh his recollection. I'm not introducing it as an exhibit. You have the video. There were multiple points where you had asked him about the registration card for the truck, correct?
That's possible.
And he was adamant that he didn't have a registration card for the truck, correct?
He said he didn't take it.
And in your investigation, was there a state-issued registration card that was ever located in any photo at all for Mr. Gutierrez's truck?
I don't recall.
You had talked about earlier you had reviewed photos from Mr. Anderson's cell phone, correct?
Some. There was 4 cell phones.
So do you ever remember seeing a state of Wisconsin registration card issued to Mr. Gutierrez that was in any of those photos?
I don't recall there ever being a state of Wisconsin registration card involved in this.
Okay. So Mr. Anderson, when he told you that he did not have the registration card for Mr. Gutierrez's truck, you did not have any evidence to support that Mr. Anderson did in fact ever possess the registration card for Mr. Gutierrez's truck.
So I'm going to object as to irrelevant whether there's a Wisconsin registration. This is a Colorado vehicle. So the absence of a Wisconsin registration is irrelevant.
Well, it had Colorado plates. Is it a Colorado registered?
I'm not aware it's registered in Wisconsin or that
Well,
that's what we're talking
No, that's not what your objection is.
I'll rephrase the question to a Colorado registration, if that would, any state-issued registration card
What's your question?
that you never found any information that Mr. Anderson was in possession of a state-issued registration card for Mr. Gutierrez's truck.
I don't know. I don't know.
And let me ask you a question. You're a detective, obviously, right?
Yes.
You've been working, you said 20 years in the force?
Yes.
When you refer to a registration card, normally in your day-to-day business life as an officer, you're referring to a state-issued registration card, correct? As it relates to vehicles.
I guess.
Were you
Where am I referring to it?
Sure, I guess an example is, did you ever work patrol?
Yes.
When you pull someone over, right?
Yes.
You'd say, hey, can I have your registration?
Okay.
Or when you ask for the registration, are you asking for a state-issued registration card or something else?
Yes, state-issued registration.
Okay, thank you. You also were asked about what information Mr. Anderson had given you about Junior or Mr. Gutierrez, and you said it was very limited, but isn't it true that Mr. Anderson admitted that he had looked up Mr. Gutierrez's information on CCAP?
Yes, he did tell me that.
And you were also asked a question about Mr. Anderson's statements about him being jealous and whether the state had asked you whether Mr. Anderson had expressed any concern about him dating, about Miss Beacham dating Mr. Gutierrez. Do you remember that line of questioning?
Can you say that again, please?
Sure. Do you remember the state asking you about what information Mr. Anderson relayed to you as it relates to his feelings about Miss Sadie Beacham dating Rosario Gutierrez?
Yes, he stated there was some jealousy.
He also stated, I'm seeing somebody else, she's got the right to see somebody else, correct?
He said that, yes.
You were also asked at length about what Mr. Anderson said he had done on May 17th, 2020. And isn't it true that Mr. Anderson in fact told you, I don't know, took a nap probably. I think I went over to my girlfriend's house, I'm not really sure.
Yes, that's what he said.
And then later he did say, in response to other questions about what he'd been doing the last 2 days, he had informed you that he was tired and really didn't want to blur things together to give you wrong information, correct?
I don't recall him saying that. I know he did say he just didn't remember because his memory is bad.
And what time did this interview happen at?
11:30-ish till just after midnight, 11 o'clock to midnight.
So you'd agree that it's likely that someone could be tired after all day and then being interviewed at around midnight?
Sure. Could be tired. Oh, yeah, sure.
You also, in talking about Mr. Anderson's interview, talked about Stephen Lenz. Remember that?
Yes.
And that's L-E-N-Z.
Correct.
May I use the Elmo judge?
Yes.
Thank you. And you said that, well, the state asked you that Mr. Lenz would be used as kind of a eyes for Mr. Anderson.
The state said that?
Well, yes. Do you remember being asked that questioning?
I remember the questioning about Mr. Lenz, yes.
And you said that there was communication between them that showed that Mr. Anderson was asking him to look in on Sadie's house, right?
Are you saying that I asked that?
No, I didn't say that.
Okay, because that long string of communication in your investigation doesn't exist, correct?
I didn't say that.
Okay. Did you see the communication between Mr. Anderson and Mr. Lenz?
No.
Okay. So you don't know what they actually talked about then?
I know there was text messages. I don't know exactly what those text messages said. I didn't deal with that part of things.
Okay, do you remember who did?
I don't know.
I want to go back now to follow up on some things that you first started testifying about. Primarily, when you first got to the crime scene, you had noted that it's important to make sure that you're very careful with how you enter into a crime scene, correct?
That's correct.
And why is that?
We don't want to damage evidence. We want to preserve it as best we can.
And in your experience, you'd agree that when you are processing a crime scene or entering a crime scene, it's important to be extremely thorough.
Of course, yes.
Now, you talked about how Officer Van Wee, some other officers came in, and that they were very experienced in evidence processing as evidence techs, correct?
Yes, they are experienced.
You said they were specialists with Kenosha Police Department, right?
They have the title of evidence technicians.
Now, do you have any specialists that deal with missing persons cases?
Nobody with the title.
So you had noted during your direct examination that you were an investigator in this case, correct?
Detective, yes.
And role of a detective in a case with a missing person is to try to figure out what happened to them
Yes,
and where they might be
yes,
and who may have been involved in the disappearance.
yes.
So besides Mr. Anderson, who did you investigate as being involved in the disappearance?
Personally, I didn't investigate into anybody else. We did look. We looked for other leads, other clues, other evidence. But personally, I didn't take the initiative to go look specifically at somebody else.
I want to pull up an exhibit. And Judge, I apologize. I'm not going to use the Elmo at this point. The state's kind enough to pull up one of the exhibits since it's already connected. And I'm pulling up what's been previously marked as State's Exhibit 1, Photo 150.
Is the TV on, though?
We're working on it.
Oh, okay. Counselor, you said 150.
150, yeah, thank you.
Looks like it's just getting.
I just want to make sure we're ready.
Thanks, Jessica. Oh, God, yeah. Thank you. So you had previously testified about this photo, and you had talked about how there's a standby screen on the TV, correct?
Yes,
And it was determined that that was a standby screen for Hulu, correct?
I believe so, yes.
Did you subpoena Hulu to get the usage records?
I didn't, no.
Could that have been something that you could have subpoenaed for?
I don't know. I have never subpoenaed Hulu.
Okay.
Possibly.
All All right, and then did you check the make and model of this type of TV?
No,
So you'd agree that there are certain TVs that have standby modes and sleep modes, correct?
I don't know.
If you left, do you have a TV at home, Officer Detective?
I do.
Your TV, if you turn it on, does it stay on or would it turn off after a certain point of time?
I don't know.
Okay, is it possible that you didn't check to see if this TV had a sleep timer or anything where it would have turned off after a certain amount of time?
I did not check personally, no.
And you agree that that could have been useful information in determining a firm timeline?
Potentially.
And then you had also talked about how there appeared to be some items that could have been knocked off, but you weren't sure. Remember that testimony?
Yes,
And you're not sure because prior to May 19th, 2020, you had never been into that residence, correct?
correct.
So the items on the floor, it's possible they had already been on the floor because you didn't know how this apartment looked previously.
That's correct.
Thank you, State. I no longer need that exhibit up. Thank you. You also talked about when you looked in and you saw some pooling of blood that you noticed a void, right?
Yes,
And I think you said that that void was where a rug would have been at some point.
that's what it appeared like to me. It looked like a rug had been there at one point.
Did you determine the size of that rug?
I personally didn't.
Do you have any information of whether any officers in the investigation did?
Not that I know of.
But you were familiar enough with the layout of and the size of the apartment, right?
Correct.
It was a relatively small apartment.
I would say that, yes. One bedroom.
Okay. So it wasn't, in your opinion, it couldn't have been like an 8 by 12 rug.
No, it wasn't that big.
It was more like a 5 foot by 7 area.
From what I recall, that seems to be about accurate.
Okay.
Maybe a little smaller.
A little smaller than 5 by 7.
Yeah.
Okay. And you said that you looked in the bathroom. There was nothing of concern there.
Not that I saw.
You went to the bedroom. You said that there was nothing of concern there.
Not that I saw.
Judge, I would like the Elmo now. I appreciate it. Thank you.
Pictures you showed me before.
Okay. Pulling up what's been previously marked as Defendant's Exhibit 60. From you being there, what room is this?
Appears to be the bedroom.
Okay.
Like the northwest corner of the bedroom.
And the window, do you see the window in the picture?
Can you change the lighting maybe? It's hard to... Maybe we could
that
turn
better?
the light off, Judge, so that...
As you wish.
Oh, okay. You need the light off, or are you good?
I'm good.
Okay.
Can you see it?
Yeah, it's fine. Yeah.
Yeah, we're good. There's a window in the picture, obviously, right?
Yes.
That window, is it open or closed?
It looks like it's cracked
The
open.
blinds or the window?
The window itself.
Looks like it's one of the panes is cracked open. Open.
Okay. And did you look into that at all? The fact that there was an open window in the apartment?
I didn't look. I guess what do you mean look into it?
So that window, I'll go back a little bit. That window is accessible from immediately right outside that apartment building, correct?
Yes, it looks outside to the north.
So an individual, if they wanted to gain access into Mr. Gutierrez's home, that could be a point of entry into that apartment, correct?
Correct.
We just saw that the window was open, correct?
So I don't know how many panes of glass are on that window or nothing like that, but it does appear as though the window is slightly opened.
Okay.
Yeah,
And that could have been a point of entry.
could have been.
So you'd agree that that is something relevant in the bedroom?
Okay.
Is
Yes.
it?
Sure, yes.
And it's important when you don't really know what happened to an investigating to determine every possible outcome or situation of how an individual might have gotten into Mr. Gutierrez's apartment, correct?
Correct.
And you'd agree that that's one of them?
Correct.
You talked a little bit about your contact with an individual named Michael Campbell.
Yes.
Do you remember what he looked like?
I don't.
Okay. So you can't remember if he had any facial hair, what his hair looked like?
I believe he had a slight beard. But like I said, it was 2 years ago. I haven't talked to him since. I don't remember.
Okay. And the state had gone into what he was telling you, but he didn't tell you that he was at Mr. Gutierrez's apartment on May 17th, 2020, correct?
I didn't hear that. Yeah, I didn't hear him say that.
And when you were with Miss Beacham, questioning and talking to her, at any point did you observe her on her cell phone?
I may have. It's possible. She used her cell phone.
Was she talking to anyone?
I don't recall.
Okay. Moving to your observations on Mr. Anderson's property, and you said you looked into the van, correct?
Correct.
I'm going to ask you some follow-up questions on that a little bit later.
Okay.
You looked in the dumpster. There was nothing of evidentiary value found there, correct?
Correct.
And you had noted something interesting, that you located lath in the dumpster?
Yes.
And in your investigation, you were aware that Mr. Anderson was doing lath removal at a house in Belgium, Wisconsin, correct?
Yes.
And you said there were other areas on the property, and just in a whole, you did not find a body on the property, correct?
Correct.
No human remains on the property, correct?
Correct.
You talked about the flannel shirt, and if the state would be so kind to pull up that Exhibit 40. Oh, no, I think I got it, Jessica. Thank you. I'm going to, for record purposes, pull up State Exhibit 42. When was this picture taken?
I don't know.
This picture, you know, wasn't taken on May 17th, correct?
Correct. I believe it was older than that.
It was much older, right? And you don't have a single photo of Mr. Anderson wearing that shirt on May 17th, 2020, correct?
I do not.
You don't have a single photo of Mr. Anderson wearing that shirt on May 18th, 2020, correct?
I do not.
You don't have a single photo of Mr. Anderson wearing that shirt on May 20th, 2020, correct?
I do not.
And you said the state had asked you about whether you searched the house and if you found the shirt. You said you had not, right?
We did not find the shirt.
Did you search Christine Remsburg, Mr. Anderson's girlfriend's house, to find that shirt?
I did not.
Did you search Miss Beacham's house to see if that shirt was there?
We did not.
So the only place you looked for that shirt was at Mr. Anderson's home.
There, the house in Belgium, a tree farm, we looked. Yeah, those 3 places.
Okay. But you didn't, there were places that you could have searched for it and did not, correct?
Essentially,
Okay. So I'm happy you brought up the house in Belgium. Were you involved in searching that residence?
me along with several others, yes.
And are you aware that the state believes that Mr. Anderson, I guess, chopped up Mr. Gutierrez's body at that residence?
Objection calls for a conclusion that I don't think is in evidence in this case.
I can rephrase and ask a better foundation question.
But-
You have no idea where Mr. Gutierrez's body is, correct?
Correct.
And you have no idea how his body, or where his body is now.
Correct.
And in fact, he's still technically considered a missing person, correct?
Objection, how would that determination by some mystery person be relevant in this case?
That does,
It's fine. I'll withdraw the question and continue on, Judge. In your investigation, you were unable to determine what, if anything, Mr. Anderson had allegedly done with the body, correct?
Correct.
So when you went to the house in Belgium, you found absolutely nothing of evidentiary value, correct?
Objection, that would call for a conclusion by the detective.
Sure, I'll go into it differently, Judge. You found no human remains at the house in Belgium, Wisconsin, correct?
That's correct.
And you know that this, in your investigation, you're aware that Mr. Anderson had been there the morning of May 18th, 2020, correct?
I know that at some point he was determined to be there. As far as the exact date and time, I don't know.
Okay. And you found no blood evidence or suspected blood evidence, correct?
At that house?
Yeah.
No.
Did you find any trash bags filled with body parts?
No.
Okay. Did you find any bloody knives?
No.
All right. Did you notice that the property was under construction?
Yes.
And did you see that there, I don't know your expertise in the line of contracting work, but you had testified you had seen lath at Mr. Anderson's home. Did you see things consistent with lath removal at that property in Belgium, Wisconsin?
Yeah, it's likely that's where the lath came from.
Okay. You noted, I want to move back to Mr. Anderson's property. You said that you had looked into the black van, correct?
I did.
And you noticed that the van carpeting had been cut out,
Yes, is missing.
missing. But you cannot definitively say your investigation didn't produce any definitive answers as to when exactly that carpet was cut out of that van, correct?
Well, objection. His investigation does have witnesses that put a time on that.
Well, then he can answer the question. I think it's a totally plausible question.
why would he be charged with that knowledge?
I'm asking him if he knows.
Well, he can answer if he knows.
Correct.
Yes, I know. I know we have it narrowed down to when it was removed.
And that was solely based on statements of another witness, correct?
Correct.
It's not based on photos of Mr. Anderson removing the carpet, correct?
Correct.
And there were no other witnesses that could corroborate that one witness's statement, correct?
Correct.
You talked about some duct tape and rope. That was also from a single witness, correct?
Correct.
You were not provided any photos of that duct tape and rope, correct?
That's correct.
And you had never observed that duct tape and rope prior at Mr. Anderson's home?
No, I didn't.
The state, kind of going back to the cross-examination or the direct examination on Mr. Anderson's interview with you, had talked about asked about Mr. Anderson not really admitting to which car he drove, but he said he drove the Audi and the van, correct?
Said he primarily drives the Audi. He doesn't really use the van.
Did he say he used the van for work purposes?
Yes.
And your understanding is Mr. Anderson's work is as a contractor?
Well, can I approach?
If there's an objection, they can state
Well,
it.
I think the question opens a door to this officer. He has some knowledge that question. I guess I have no objection. The question was asked, what is his current job, or what's his source of income? If that is
exactly, but
that question's been asked. Let's let it be answered. I don't object.
all right, everybody's on board, so.
You go ahead and answer.
Oh, no. Oh, if we can have one moment. I'm going to re-ask the question.
Judge, I apologize, Judge. There was no objection. Can he answer the question?
Do you remember the wording of the exact question, officer?
Yeah, what he did for work?
Well, were you aware that Mr. Anderson was doing contract work at that time?
Yes.
And there was evidence that Mr. Anderson admitted to that proves that he was driving the Audi around this time, primarily that he was driving the Audi on April 24th, 2022, correct?
I don't know if he specifically told me that. He did say he was operating a car that night.
Right. And that was confirmed by other witnesses.
Correct.
Okay, I'm putting what's been marked as Defense Exhibit 59 up on the screen. Do you recognize this?
Yes.
Okay. And that was a pizza box and receipt that was on the stove at Mr. Gutierrez's apartment, correct?
Yes.
Did you investigate this at all to see when this delivery was dropped off?
I did not.
Do you think that would have been useful if maybe if it was dropped off, let's say, on the 17th at night to talk to the delivery driver?
Potentially.
Because that delivery.
If it was, I don't know when it was dropped. I didn't look at the receipt.
But there's potential investigatory points that could have been covered in investigating this,
Potentially, yes.
and it wasn't, correct?
No.
Are you indicating that nobody did this, or he did not personally do this? Objection as to vagueness, I don't understand the question.
You can cover it on cross or redirect
Okay.
And I'll even cover it.
if the witness understands the question.
I didn't investigate it.
Okay, and I'll just ask the question the state wants to ask, which is, are you aware of any other officers investigating this?
Huh?
Okay, so I'm going to object because it implies that he would know if other officers did. No one has indicated that he would have some overall supervision of this investigation, Judge.
He's previously testified that he was one of the lead detectives in this case.
Well,
I don't believe he had.
I never said that.
he testified that when he arrived, there was one other detective who was there, but I don't recall any testimony that he is saying that he was the lead detective, but I don't know if he did or not.
Were you aware of other tasks other detectives and officers completed in this case?
Some.
Okay, and the some that you do you know if anyone investigated this?
I don't know.
Okay, thank you. Showing what's been marked as Defendant's Exhibit 61. You're familiar with the fact that, well, let me strike that, rephrase. Did you look at the dumpsters in Mr. Gutierrez's or near Mr. Gutierrez's apartment?
No.
Are you aware that that happened?
I don't know.
Okay. You were at Mr. Anderson's home, correct?
Correct.
You looked around the property, you said before, right?
Correct.
It says marked as Defendant's Exhibit 76. Did you notice the trash bags up against the barn at Mr. Anderson's home? I'll zoom in for you if you need.
I don't recall.
Okay, but you'd agree those are trash bags in this photo, right?
That's what they appear to be, that, yes.
Okay, great. Then you said when you were at Mr. Anderson's home, you had looked into the van, correct?
Through
Did you
the
look
window.
at the front window too?
I believe I made my way all the way around the van.
Okay, so I'm going to show you it's been marked as Defense Exhibit 62. Is this an accurate depiction of the front seat of Mr. Anderson's van?
Appears as such.
Okay, and there were tools in his van, correct?
I believe so.
You'd agree that those are tools or a toolbox of some sort on the front passenger seat?
Yeah, tape measure, tools, looks like a tool bag.
Okay. And you'd agree that there's a lot of cluttery stuff around there too, right?
Yes?
Okay. I'm going to show you what's been marked as Defense Exhibit 65. This is another view from the behind of the vehicle, correct?
Correct.
And you'd agree with me that there's a lot of dirt and stuff on the floor, correct?
Looks dirty.
Looks dirty. It hadn't been vacuumed or meticulously cleaned, correct?
Doesn't appear as though.
Okay. I'm going to show you another picture of the front, Defense Exhibit number 66. Again, lots of items, correct?
Yes, very busy.
And this is how it appeared to you on, was it the 20th of May?
Yes.
Okay. And another angle of the front seat taken from the passenger, Defense Exhibit number 67. Again, lots of items, correct?
Yes.
And this is how it appeared to you.
From what I recall.
Okay, great. Showing you more pictures of clutter here.
Yeah.
Defense Exhibit 68. This is the front of the vehicle, correct?
Yeah, between the two front seats, looks like.
And we still see a lot of that clutter,
Yes,
and that's how it appeared to you?
what I recall.
I'll show you another picture from inside the van. Defense Exhibit 69. I think you can see that dirt and trash a lot more clearly, correct?
Yes,
Does this look like a car that has been cleaned to you?
doesn't appear so.
You said you also went to the tree farm to help with the search that was executed there?
Yep,
And you're aware that there was a burn pit at the tree farm?
yes,
And multiple agencies had come to process that burn pit, right?
yeah, there was approximately 100 people that took part.
And you were able to confirm that there was a controlled burn there on May 8th, 2020, correct?
I believe that was the date. Yep,
And that the owners of the tree farm had alerted the Ozaki County Fire Department of that burn.
I believe so, yes.
So I'm just going to show you some pictures. This is Defense Exhibit number 70. This is part of that linear search of that burn pit, correct?
Yeah, so I didn't take part in most of that
Okay.
search. I was doing other things.
Okay, but
But that looks like the burn pit, and that looks like what they were doing.
Sure.
Searching.
so maybe I'll just ask you then, you were aware that that was a large operation,
Very large, yes.
and they didn't find any human remains there, correct?
Not that I know
And they didn't find any bloody evidence there, correct?
of. Not that I know
Okay. Back to Mr. Gutierrez's home, I'm going to show you what's been marked as Defense Exhibit 58. The number of his apartment building, 3709, that you can see that in this exhibit, correct?
of. Yes,
And that 3709, you can see that from in the parking spaces right in front, correct?
yes.
And you had been at this scene during the day and at night, right?
No, I was there during the day.
Not at night? Okay. As part of your investigation, you talked to an individual named Kim Lavora.
I did? Kim Labora?
She also goes by Undendum Lavora. I can go get your reports if that would help.
Yeah,
refresh
you
your memory.
need to
Okay.
clarify that one.
Yeah.
We talked to a ton of people,
Yeah,
so.
no.
Yeah, Counsel, I'll stipulate to the record, if you just want to do that, you're not going to ask what he asked or anything.
Correct.
So I'll stipulate rather than, if you want to refresh, you can, but if you just want to.
I do want to refresh.
Okay,
Thank you.
yeah.
Could hold those ones in the red file till tomorrow.
Guys.
Kim? Oh, okay.
Counsel, for purposes of the record, you don't want him to read it out loud, you're just
No.
refreshing his memory.
For purposes of the record, I've handed the detective a copy of his own report to refresh his recollection. Does that help?
Yes.
phone records were obtained in this case from Mr. Gutierrez, correct?
Yes.
And I'm going to show you what's been marked as Defense Exhibit 75. Probably going to have to zoom in here and focus, so bear with me.
Well, given the hour,
This is going to, go ahead, Judge.
well, if this, it's going to be brief.
With this point, yes. Then I have some other stuff. But
Well, I
I'm-
know that. I wasn't going to end your entire examination. But it's 1 minute to 3 minutes.
This will be like 1-2 questions max.
All right, I'll hold you to
Okay. I won't disappoint.
that.
So this phone record shows that these are Mr. Gutierrez's phone records, show that he called a Kim Facebook on 5/17/2020 at 8:49 p.m., correct?
Appears as though yes.
And that when we look further up, there's a duration column, and the duration of that phone call was 17 minutes 4 seconds, correct?
Appears as though, yeah.
I lied. I have 3 questions, Judge. So if there's a phone call that started at 8:49 that lasted 17 minutes, that's going to put that phone call to approximately 9:06 p.m. I'm terrible at math.
Yes.
Okay. Thank you. Judge, if you wanted to take a break.
Well, I'm only doing it for others. But let's take a break, and please don't read about your list or any account of the trial. Discuss the case with anyone. And let's aim for about a 15-minute break. Any questions? Okay, thank you. Okay. Shall we begin?
Yes.
Hello?
Would you come down, please?
Yes.
Thank you.
You want the officer, you want the detective to go back on the stand?
Yes, please.
Yeah, going back up. Detective. Yeah, sorry.
One minute. Weird.
Yeah. Okay. Yes, go ahead.
Thank you. All right, I'm pulling up what's marked as Defendant Exhibit 63. This is picture of the dash in Mr. Anderson's van, correct?
I'm going to object, Judge. The detective has indicated he took a brief glance in without entering the van. I don't believe he's a witness who would be able to talk about details of the of areas in the van that are not the cut area in the back or the bleached area that he's testified to. So this is a close-up view. He says he took a brief glance. I don't think he's a qualified witness to testify to this exhibit.
He can respond if he doesn't know the answer.
I don't know what that is.
Okay, that's fine. That was 63. I'm going to ask you about some dates and what you reviewed. If you need your recollection refreshed, just let me know.
Okay.
Do you remember on May 25th, 2020, reviewing video footage from a High Line gas station?
Yes.
And that gas station was located near Mr. Anderson's home, correct?
I believe it was at the interstate near the tree farm.
Okay. And so if it was in Ozaukee County or Sheboygan County then?
Ozaki?
Okay.
I'm guessing. I'm sorry.
It's fine. I could give you the locations you put in your report. I don't know if that would help. You said
Please.
located at Interstate 43 and County Road D.
Correct.
Okay.
Yep.
So Ozaukee County?
Yes.
And the reason that that gas station was important was because if Mr. Anderson had traveled to the tree farm or back from his home, he would have passed that gas station, correct?
Objection. We don't, the detective would have no ability to know the route that somebody took to get to someone's home. Presumably, there's a number of highways, number of roadways.
I'll rephrase it. Why was getting and reviewing the surveillance video of that location important to law enforcement in this investigation?
It was a potential route of travel.
Okay. And you reviewed several hours of video, correct? For the Highline gas station.
Yes.
And you reported that you did not see Mr. Anderson's black minivan, correct?
So the cameras were substantial distance from the road, and at nighttime, it was almost impossible to tell what cars were going by. So I don't know what cars are going by. No, I didn't see a black van drive by.
And in your report, you were clear that you reviewed several hours of video and did not see the black minivan.
Correct.
You also indicated that on May 26, 2020, you continued to review video surveillance, correct?
Of what? What surveillance are we talking?
Yeah, I was hoping you could answer that. Can I show you your report?
Sure.
Okay.
Sure. So
Did that refresh your recollection?
yeah, so we had hours and hours and hours of video from multiple locations we took. I didn't document what I looked at there, but we reviewed several locations. I don't know specifically what I was talking about when I mentioned that in my report.
But is it a fair guess that those were locations of interest due to potential traffic patterns of Mr. Anderson?
Potential routes, yes.
And in your report, you noted that you observed nothing of evidentiary value, right?
Correct.
And can you explain to the jury what nothing of evidentiary value means?
I saw nothing regarding a black van, a black Audi, or anything related to Mr. Anderson.
I have no further questions subject to redirect.
I'm going to start from the back. So you were just asked about some video that it sounded like it was a gas station location that you looked at,
Yes,
and that appeared to be on May 25th, 2020, correct?
correct.
You wrote a report that memorialized those fascinating hours, I assume, right?
Yes,
Counsel read to you, I reviewed several hours of the video and did not see the black minivan. Do you recall that just being read to you?
yes,
Is the next sentence in your report, however, the video was from a great distance, making it difficult to make out traffic, especially during the hours of darkness. Is that what you say next in your report?
that's what I testified to as well.
And so when counsel read to you the first sentence, you had already also tried to testify as to the second sentence, and it's also in your report. Is that right?
If you just read it, it's in their report.
You have no reason to dispute it. Would you like to take a look?
Sure.
I'm going to object. This witness has already testified to that contents, and the video was poor quality and it was dark.
Well, sure, you saw it's the next
Yeah,
sentence.
yeah, yeah. What page? Wait, actually, Mike, what page is that?
It is. So I'm just going to ask you to take a look at your report and ask you, do you agree that after the first sentence that was read, there is a second sentence, and it's what you testified to?
Yes.
Okay, so it's also in your report, is that right?
Yes.
You were shown on the doc cam just a minute ago, or I'm sorry, before the break, the signage indicating what the 3709 address for apartment 1B. Do you recall that?
Yes.
And that picture was one where you said that the sign was visible, correct? Like would be visible from the road.
Yes.
Do you recall
from
testifying?
15th Street, right? From the road.
Can I see it? Yep. So I'm going to show that to you on the doc cam again. Does that appear, as best you can see, to be? Of course, I forgot that you got to do that. Does it appear to be a daytime photo, if you can tell?
It is.
Okay. At nighttime, would you expect there to be substantially different visibility?
I'm going to object. I asked this witness if he had been there at night, and he had said he had not. So it'd be purely speculative.
Well, I think he could.
Go ahead.
At night, would you expect that signage to be significantly more difficult to read?
I would believe that to be a safe assumption.
Okay.
It's dark.
And on the 17th of May, do you believe it to be heavy? Was it heavily raining?
Yes.
Was it heavily raining at night?
Yes.
Have you, and so if I add in heavily raining at night, would you expect the signage 3709 to be different and more difficult to read than it is in the current state of the daytime photograph?
Rain would obstruct the view of the sign at night.
You were shown a picture. It is Defense Exhibit 65, where you were asked if whether the van, and this is the defendant's van as best you know, correct?
Correct.
You were asked if it appeared to have been meticulously cleaned. You recall that?
Yes, that's what I was asked.
Okay. Now, this is not the same view you saw. You saw the van during the day, for instance, correct?
Through a window, yes.
When you saw it, did it appear to have been selectively cleaned as opposed to comprehensively cleaned?
Yes.
Okay. And what left you to the conclusion that instead of someone comprehensively cleaning the van, and have you ever cleaned one of your cars?
Yes.
Do you normally, detective, clean only small portions of your car? Say, if you have a minivan, do you only clean the back third?
Typically not, no.
Would you use bleach on just certain locations, or do you typically clean the entire automobile if you are engaged in your normal activity?
I'd clean the whole automobile and I wouldn't use bleach on a carpet.
Okay, so when you observed what appeared to be bleach stains and the back cut out, was it your sort of at least beginning conclusion that somebody had made some efforts to do something to that minivan that wasn't involved in just trying to keep it clean?
Yes, it definitely wasn't normal.
I'm going to show you what's been marked as State's Exhibit 59. Do you recall this pizza box from your walkthrough of the scene?
I know there was a pizza box, but my walkthrough was what it is, a walkthrough. I didn't stop and do crazy examinations. I didn't evaluate evidence while I walked through the residence to get a gist of what happened.
So I guess I'm going to ask you plainly. Are you the best person from the Kenosha Police Department to testify as to each of these areas or items and whether anyone collectively on this investigation did anything further? Are you the ideal person to ask those questions to?
No.
For instance, if a officer called the pizza place and made some determination that this was not an issue in this case, in other words, in terms of the timing, would you know that one way or another?
No, I know some things. I don't know others. I didn't lead the investigation.
Okay.
I assisted.
As to the specific fact I asked you,
Yeah.
if an officer made that call and determined it was not an investigative lead, Do you know that, or would you know that?
Not necessarily.
Okay, and in this case, do you know that?
No.
You were showed a picture that is defense exhibit, apologize, 76. Do you recall this?
Yes.
You recall that it was, I believe it was honed in, and there's some garbage bags along the side of that particular building. Do you see that?
Yes.
And you were asked whether that was something you personally had reviewed, I believe, correct?
Something to that extent.
Are you aware that in the context of this investigation that those garbage bags were the remains of marijuana grow, that they are potting soil and other remains from a marijuana grow?
I'm going to object on the grounds that, one, speculation, lack of foundation. As he already testified, he did not look at those bags, look in those. It's also an argumentative question.
Well, counsel brought it up. I didn't open this door. He's either aware that that's what the contents of the bag are or not. That would lead a reasonable jury to decide, is this an investigative lead about a missing body? If it's bags of potting soil for marijuana, then it would be reasonable to conclude that's not that's not necessary in terms of this investigation.
Well,
And I didn't bring the bags up, they did.
You're asking him about what his awareness was?
Yeah, which is what they asked.
Well, but the investigation is an entire group of separate inquiries. And
Absolutely.
if having an adequate investigation also involves proper coordination
Yep.
of various reports and observations. So you're asking him if he is aware.
Right. Which is my redirect question to their specific cross-examination. I'm using the same phrasing. He's either aware of it or not. If he's unaware of it, obviously I would have to put in any affirmative evidence of it with some other witness. But this is a question of whether he's aware, because the topic, I assume what my redirect is directed at is, if I am correct that these are marijuana potting soil bags, a quantity of them, then obviously they don't have an investigative lead quality here. And again,
That's argumentative.
apologize, they brought it up. So
Now the objection is sustained.
as to his awareness, the question as to his awareness.
Yes.
Okay, all right. You were asked by the defense on cross-examination, counsel, whether there was any videotaping of the defendant cutting the carpet out of the van. Do you recall being asked that question? Whether there was any videotape available of him, of the defendant cutting the carpet from his van during this period of time, or pictures, either
No
video or
photos.
pictures.
Yeah, and there was no photos.
Okay. Would you expect someone who is trying to remove blood evidence from their van to videotape themselves or take pictures of themselves during that process? Is that something you would expect?
I'm going to object. This question is tending towards argumentative.
Sustained.
Yeah. You were asked whether on cross-examination whether Anderson's home had any body parts at its location or any other blood evidence. Am I correct that the search warrants at Anderson's home were 2 days and 3 days after the time you believe that Mr. Gutierrez was murdered?
Yes.
Okay. And do you have any specific reason to believe that at any point that Mr. Anderson either stored the body at his home or did any of the blood work at his own home? Do you have any reason to believe that?
No, we
Okay.
found nothing to suggest that.
And so, again, would a person having 48 hours to no longer be in possession of the body of Rosario Gutierrez or of any of the blood evidence, would a person have enough time during that period of time to either not have that evidence at their home and also to dispose of that evidence? Is that a sufficient amount of time?
I'm going to object. This is beyond the scope of my cross-examination. And it's also argumentative.
As to the first objection, as I think I commented the other day, I am always hesitant to limit an examination as not within the scope unless it's really things that ought to have been fully covered earlier. So I'm going to overrule you on that. On the fact that it's argumentative and speculative. Speculative.
I thought the argumentative objection is me being argumentative with a witness. I'm not aware of argumentative being, that there being another form of argumentative. I thought it
There
meant
are
to be.
two forms.
Okay.
One is arguing with the witness, which is really is a branch of things that ought to be taken up in argument, and the lawyer is simply attempting to have the witness testify in a way which is a substitute for the argument. That's really the principal problem with argumentative questions, but it can be both. But it's also speculative. I mean, I think your question is, and correct me if I'm wrong, I think your question is, how long does it take to dispose of a human body?
Or, well, not how long, but can it be done in 48 hours before this search warrant is done?
Don't know.
Well,
I don't.
okay. Okay.
I've had lots of pathologists up here, and we'll probably have it before this day is or before this case is done. Oh no, we won't. No, not in this case. But that would be speculation as to how long it would take to dismember or otherwise dispose of a human body.
Well, I mean, I'm not aware of any specific evidence that there was a dismemberment. One can just bag up a human body and place it
Also
in a
true.
dumpster.
Also true.
Okay?
Well, but dismemberment might be the more efficient way to do it. I don't know.
Possibly.
Go ahead. No, but the objection is sustained.
So you were asked whether you saw a picture of the defendant in a flannel shirt. Do you recall that?
Yes,
And when that picture, and you don't know when the date of that photo was.
I don't.
Your reason for focusing on that flannel shirt is you have multiple witnesses who told you that just hours before Rosario Gutierrez is murdered, in your belief, that he's wearing that shirt. Is that correct?
I'm going to object again on argumented grounds and foundation. There's been no testimony as to what time it's believed that Mr. Gutierrez was murdered or went missing.
Well, the problem I'm stumbling on with the question is what the detective's belief is. As I say, this gets into the argumentative, the subject we were just talking about. This is really part of your argument later in the case that is attempting to be extracted from the witness. And the witness, in order to respond, it seems to me has to employ a lot of speculation.
Well, he has a working theory as to when this occurred. And he is, remember the flannel shirt is a focus of the search.
Right.
Okay? So the cross-examination question was, well, you're basing this just on 2 witnesses, you have no photo at the time. So it is redirect to say, well, you have 2 witnesses and they are close in time because we have no photograph of him that day. They are close in time to your working theory of when Rosario Gutierrez is killed. So that counters with his testimony that his basis of focusing on the flannel shirt is that multiple witnesses say just hours before Rosario Gutierrez is murdered per his working theory, based on electronic evidence, etc., that they see him wearing this flannel shirt. So it's not remote in time, which is the suggestion of the cross. And so the redirect is to show that, not that it's true, right, but that he's been provided information that it is recent in time.
If I may respond?
All right.
Thank you. First, if the state wants to ask, do you have a theory about when Mr. Gutierrez went missing, then that's the proper question to ask to lay the foundation for this series of questions, not to ask a speculative, argumentative question without laying that foundation. I have not heard any testimony from detective about his theory of when Mr. Gutierrez went missing or was killed. So again, I maintain the objection.
Counsel and Cross did not ask any foundational questions in that regard either. Why would he have to explain the theory if he's simply indicating it's near in time?
Well, given the opening statement that was made by the defense,
Yeah.
I think that the existence of a, quote, working theory, unquote, may be a line that you might want to pursue and could, but that's not entirely clear thus far. And number 2, the way it's being presented is, in my opinion, argumentative, and also it's speculative. The objection is sustained.
When were you told that the 2 witnesses who are your source that the flannel shirt was being worn, what was your understanding of the time that they indicated they last saw the defendant in the flannel shirt?
I believe it was around 4 o'clock Sunday.
Okay, Sunday is May 17th?
Yes.
And are you a person who has knowledge of the electronic evidence of this case, at least in the general sense?
I know some.
Okay. And is, on the same day, is Mr. Gutierrez believed, based on the electronic evidence and his absence of any more responses after, is he believed to have been killed at a time in the area of 10 p.m.?
I'm going to object. This is already extremely leading.
Well, you could say that.
Between 9 and 10 p.m. on the same.
Wait a minute.
I apologize. I thought you said yes. I apologize.
Oh, I'm sorry. I said it seemed it was leading.
Okay, I'm on redirect.
Right?
Okay, so I'm trying to direct him to the place that the court asked me to. The only other avenue I would have to ask this question is to ask him to explain what time, when he is not the detective who formulates that.
The objection to a leading question is based upon the fact that it is suggestive of the answer. And the form of your question was suggestive of the answer.
What time period, in your knowledge, detective, is the time period where it appears that Rosario Gutierrez has been murdered?
Between 9 and 10 on Sunday the 17th.
That's the same day as as you've indicated, around just before 5, that the 2 witnesses saw him in the same in a flannel shirt that seems to match the picture.
That flannel shirt, yes.
You were asked whether Michael Campbell had offered you information that on May 17th that his phone was at the home of Rosario Gutierrez at some point. Do you remember being asked that question?
Yes.
And you knew that Michael Campbell was a friend of Rosario Gutierrez.
Yes.
Did it cause you any concern that he did not, that his friend did not tell you that he had some contact with his residence on some period on May 17th?
No.
And are you aware, pursuant to this investigation, that contact that they're speaking about is actually at 1:45 a.m. when you have just indicated that your thoughts on this case is that it would be 20 hours later, 9 or 10 p.m., that Mr. Gutierrez is murdered? So it would be 20 hours earlier. Are you aware of that?
No.
You were shown a picture of the bedroom of Rosario Gutierrez. Do you recall that picture?
Yes.
And that picture had a window in the far side of it, correct?
Yes.
Are you also aware that the reports in this case is that the slider that would face the street was also found open in this case?
Yeah. I don't know.
Oh, you don't know? Okay.
I'm sorry, the sliding
door
in the living room.
Yeah.
I thought we were talking about the bedroom window.
I apologize. I meant the sliding door in the living room. Are you aware that was found open?
That's what I was told, yes.
The screen was closed?
Yes.
Okay. So that would be another logical method of entry, correct?
Yes.
Simpler method of entry than climbing in a window, correct?
Yeah.
The blinds were in no way disturbed that you saw in the picture, were they?
Not that I saw.
And did that picture include notes on it? I'll show you.
I believe on the pillow on the bed.
I'll redirect you there.
Judge, if I can have a sidebar on this issue of line of questioning.
You probably haven't had an opportunity to see all of my brewer's pictures in the back. So why don't we take 5 minutes, we'll be able to do that. Opening day is coming. So please don't talk about the case during this very short break.
If you're going to check.
The last few years, there hasn't been much demand in my group.
The preemptory position that the defense was noting here is there is a piece of paper on the pillow on the bed that's a note from Mr. Gutierrez's daughter. The defense's position is that the contents of that note are not relevant to this case. I could see the potential argument that the state would want to make by introducing that there's a note on the pillow if they're going to try to loop in that, oh, he must have not slept there then that night of when it was put there. That's fine, but the defense would object to going into what the note says based on the fact that it's not relevant and the defense's position would be that the introduction of what's in that letter would be simply to garner sympathy and appease to the emotions of the jury, which would be inappropriate.
I intend to just simply indicate the first thing that counsel said. I did not intend to ask about the contents of the note. I just intended to ask, is this a note that was determined to be a note from the daughter? When was the daughter there? She was there Sunday into the afternoon. And that is a piece of evidence that the bed was never slept in after May 17th. So I didn't intend to go through the content. In fact, I'm not sure he'd be able to read the content of the note. So.
And I think too, I mean, there's no evidence if it's from her daughter, the daughter, or the son. So as far as who the note's from, I think too is irrelevant. I think if the state wants to say there's a letter on the pillow, that should be the extent of the inquiry.
It's signed.
Is it signed?
It's signed by the daughter. Yeah.
Well,
And again, I'm not going to get in the content because I don't want her name to come up other than that it's the daughter. But again, I think it is another way to time this out. This is this is an exhibit introduced by the defense for this witness. So obviously we have other witnesses coming, but I think it's valid redirect.
well, here's the problem, and I'm not criticizing anybody. This case is coming in with an enormous amount of evidence, which ordinarily would be totally inadmissible. And you said it a moment ago when we first started talking about this, you referred to it as a note which has been determined to be from the daughter. So there's some more that we're not apparently going to get into, but it's an example of how things, without any sponsorship, are getting into the record. And it really is bothering me quite a bit. Now, I'm not saying anybody's done anything that isn't right, but the sooner we can move into what would ordinarily be received as circumstantial evidence, the better. Apparently, this is not a problem which is going to torment us, so I'm not going to worry about it, but just make a timely objection if you think something's going on that oughtn't. Okay? Now, let's let the jury on.
Well, can we get a ruling, though, on the scope that the state can go into as it relates to that?
As I said before, I really can't pre-screen.
Understood. So I'll just
Go into.
Understood. I will then just renew the objection where I find appropriate.
Thought his purpose, I understood, was to demonstrate that it did not appear that the bed had been slept in during the period indicated.
Since she left, since the note was placed there.
Yeah.
Right.
Okay. Didn't I veto a couple of them? No, I didn't. I should have. What's that? Down on a contempt, yes.
Shall I proceed?
You please do.
Okay. Detective, I again ask you to turn your attention to Defense Exhibit 60. You've indicated previously that's the bedroom. Is that correct?
Correct.
Okay, and that there was no DNA, there was no blood evidence that you saw at, again, in your opinion, in this room, is that right?
Not that I saw.
Conditions were muddy and rainy on this day, is that correct?
Yes.
Was there any evidence on the windowsill that you yourself noticed that somebody would have entered knowing that it was wet and rainy over the last several days?
Not that I saw, but I also can't say I examined it thoroughly either.
That's not something you focused on?
No.
Is there a pink note on the bedroom pillow in this depicted here?
Yes.
And is that a note appears to be the author appears, at least by the note, to be the daughter of Rosario Gutierrez?
I'm going to object as far as foundation and speculation.
Oh, I thought that's where we.
I thought
that's where we drew the line.
That was my impression that
The defense's position is that it's not relevant what the contents of the note are or who authored it.
I certainly remember the first part. I'm afraid I don't remember the second part of that. The remark that I made at the time was that that it was again a question about the sponsorship. Objections overruled, but I think that was the understanding. That's as far as we're going with that.
That was my understanding.
Okay.
And I don't want the name of the individual, but does the note appear to indicate an author?
Yes.
And is that is the author a person related to Rosario Gutierrez?
His daughter.
His daughter. Okay. And is the note placed physically on a bedroom pillow?
Yes.
Are you aware of when last Rosalio's daughter was located at his apartment so she'd have access to his bedroom?
Yeah, she was at the house on the 17th through the early afternoon-ish hour.
Okay. So that pillow had a note on it, and that daughter is under 10, correct?
Yes.
Okay. And she was last at the residence on the 17th in the afternoon?
Yeah.
Something back, yes, it's gonna press, yeah, slide it one way and then pull it down. There you go.
That's much better.
Detective, what is your estimate on how many interviews you personally were involved in this case? What would be your general estimate?
25 or so.
And
around.
and did that involve a number of people, a wide variety of people from all those different directions in this case?
Yes.
And at any point that you came upon something that was evidence that persons were involved somehow in the disappearance or murder of Rosario Gutierrez, at each of those occasions, did you pursue that evidence when it was apparent to you based on all those interviews?
If I didn't directly, I would pass it on to other detectives that would follow through with that.
Further questions, Your Honor. Thank you.
Yes, thank you, Judge.
Yeah.
I don't know if you want me to pull up the... Thanks, Jessica. So the state had in redirect asked you about that there were portions of the van that had been selectively cleaned. The area under where the missing carpet is, that area, to your observation, had not been cleaned, correct?
I'm sorry, what area?
Where the metal is exposed, that there was dirt and other items that show that area had not been cleaned?
Objection. The removing of the carpet would be the cleaning.
Well, I'm asking if under the carpet was cleaned.
Irrelevant whether you've cleaned under the carpet.
I don't think that's,
I don't want to preclude her examination, oral.
I can re-ask it, that
Please.
in that area, sorry, Detective, in that area where the metal is showing where the carpet used to be, there's a lot of dirt and other scraps indicating that that area hadn't been scrubbed clean, correct?
There is dirt and there is things over the metal.
Okay, thank you. I don't need Exhibit 263. Thank you, State. The state had asked you about the efforts that you observed in the minivan were concerning to you, and you had said that it was not normal, correct?
Correct.
But you'd agree there are plausible other explanations for why an individual cleans a work van, correct?
I'm sure you could come up with some.
Okay. And the state had asked you about the screen door being open. You said yes, but you were not the first officer on scene, correct?
I was not the first officer, no.
So you wouldn't know how that door was observed when officers first responded?
Correct.
The state just now, the last question that it asked you, had to deal with all the interviews that you had with people, so I want to kind of break that down a little bit. You spoke with Michael Campbell, correct?
Yes.
He was just a friend of Mr. Gutierrez.
Correct.
You spoke to Eileen Knoll, correct?
Correct.
She was a friend of Mr. Gutierrez.
Right.
And they didn't provide you any investigatory leads, correct?
Correct.
You then spoke to Sadie Beacham, correct?
Yes.
And it was your prior testimony that she had immediately stated that she believed her ex, Zachariah Anderson, had something to do with it, correct?
Yes.
And you followed up on that one, right?
Yes.
All right. And you also spoke to Olivia Anderson, correct?
Yes.
And that was in relationship to Mr. Anderson, correct?
Yes.
You interviewed Mr. Anderson himself, right?
Yes.
And you interviewed Christine Remsburg, correct?
Yes.
That was the girlfriend of Mr. Anderson?
Correct.
So she only dealt with Mr. Anderson, right?
Yes.
And you interviewed, I'm probably going to butcher her name, but Casalina Remsburg?
I believe she went by Cassie, yes.
And that's Christine Remsburg's sister, correct?
Correct.
Again, relating only to Mr. Anderson.
Yes.
And then you spoke with Andrew Schultz, correct?
Correct.
That was a friend of Mr. Anderson's, correct?
Yes.
And then you spoke to Alex Wetzel,
Yes.
again, a friend of Mr. Anderson's, correct?
I believe it was a cousin.
You talked to him only as it related to Mr. Anderson, though, correct?
Correct.
And then you spoke with an individual named Amber Stark.
Yes.
And she was the girlfriend of Alex Wetzel, correct?
Yes.
And that had to deal with confirming his whereabouts the weekend of May 17th through
Objection
May.
is to hearsay.
I'll rephrase the question, Judge. You spoke to her as it relates to your investigation of Mr. Anderson.
Correct.
And then you met and interviewed Solomon Anderson, correct?
Correct.
And that's Mr. Anderson's brother.
Yes.
And then you interviewed Jennifer Libers, correct?
Yes.
And that's Solomon Anderson's girlfriend, correct?
Yes.
And then you interviewed Joshua Anderson, correct?
Yes.
That's Mr. Anderson's other brother, correct?
Yes.
And then you interviewed Zenith Anderson, that's Mr. Anderson's sister, correct?
Correct.
Then you interviewed Stephen Lenz, correct?
Yes.
That's a friend of Mr. Anderson, correct?
Yes. Correct.
So who did you interview that provided you other investigatory leads other than Mr. Anderson?
I didn't say I found any.
I didn't say,
I didn't say I found any other ones.
No further questions.
Were you just asked whether you spoke to Umdeen Lavora?
Yes, that's another one. Kim?
Was that included in the list you were just asked?
No.
Okay, so that's not a person related to Mr. Anderson, is it?
Correct.
Okay, and when you spoke to Michael Campbell, he provided you information that Rosario Gutierrez had given him that led you towards the defendant.
I'm going to object as far as hearsay. Also leading.
Judge, there's just been a whole series of people listed, and they said there are no investigative leads that you pursued. I'm suggesting there are investigative leads on certain ones, and I'm asking,
He's
again,
now-
using the identical list of people that they just talked about. I'm not required to only talk about whether he found any leads that don't involve Mr. Anderson.
Judge, if I may, the state asked him, oh, you interviewed a bunch of people and you followed all those investigative leads. I then went into all the people he talked about. I asked him about Michael Campbell. He answered it. Now he's trying to go into exactly the information that Mr. Campbell had allegedly provided. And additionally, if the state is going to make commentary about what he wants the witness to answer to, I'm going to ask that that be done outside the presence of the witness.
let's just, much of the evidence you're hearing throughout this case would ordinarily not be admissible under that big rule, the hearsay rule. When I was in law school, had a book very like this, and about a third of the entire book was about the hearsay rule. The hearsay rule is a very, very, very complicated rule. It has many exceptions, things that you might think would qualify as hearsay. And hearsay is evidence of an assertion made by a person while the person was not in court, under oath, and subject to cross-examination, which is offered in evidence to prove the truth of the matter asserted. So it's not anything that somebody said who's not on the witness stand. Sometimes that's what it is. But sometimes, a lot of it isn't really being offered to prove the truth of the assertion. It's being offered to prove something else. And in those cases, it's not hearsay. Then, if it is hearsay, it's subject to a large number of exceptions from the hearsay rule, which even though the testimony is hearsay, an exception permits its receipt into evidence. And believe me, we could take months and talk about this. But there are many times when hearsay does find its way into the court record. I've never seen a case in which so much hearsay has come in. And I'm not suggesting that it hasn't been proper or that the lawyers haven't
So that's where
used it properly, but you're hearing a lot of hearsay that would ordinarily not be brought in. The critical feature for almost all of it that you're hearing has been that it is not being offered to prove the truth of the underlying assertion. And we're at that point again now where I'm going to allow the witness to testify about what Mr. Campbell, what he claims Mr. Campbell said to him. And it's not being received for use to prove what Mr. Campbell is reported to have said is true. It's not being received for that purpose, and you're not to hear it for that purpose. It's being offered in response to the defense contention that the police investigation was deficient, and what the district attorney wants to show is that the police were investigating and did receive some information and then made a determination about whether it was worthwhile pursuing or not. It is, again, he's not the final judge of what's true and not true. It's just he has to make a judgment for purposes of his position about whether this is something worth pursuing. The burden of proof in the case is totally unchanged, and that is for the state to prove the charges against the defendant beyond a reasonable doubt. And what leads the officer decides to follow and those that he doesn't are really not relevant to that. And all this evidence that is coming in that is ordinarily hearsay is being received just in response to the defense claim that the case wasn't properly investigated. And I might add, in my final comment, is that the huge portion of the book about the hearsay rule, I still remember the first sentence. There is nothing murkier in the law of evidence than the hearsay rule. So it's a very, very complicated rule, but I just want to caution you in this case that ultimately you must rely on facts which are proved by the case and are proved by proper evidence and that are sponsored by the person who, generally sponsored by the person who's making that assertion, who's here and subject to cross-examination. I know I could have done a better job of this, but is there anyone who has any question about this? Okay, I'm going to overrule the objection and permit the question with that understanding.
So, Detective, my question was, I'm not asking for the content, but was Michael Campbell a person who provided information to law enforcement that would conclude, that would lead them to go to further their investigation of the defendant?
Yes.
Did Eileen Knoll, when questioned about what circumstances she was aware of and helpful on, did that cause you and other law enforcement to further direct your investigation towards the defendant?
Yes.
Did Sadie Beacham, in her interview, give you factual circumstances and things to investigate consistent with the defendant being the person responsible for these crimes?
Yes.
Did the defendant's daughter, when interviewed, give you information, eyewitness information and witness information that would lead you to further investigate the defendant?
Yes.
Did Christine Remsburg, the defendant's girlfriend, provide you substantive information that would lead you to continue and further your investigation of the defendant?
Yes.
Did Cassie Remsburg, her sister, provide you information that was consistent with that as well?
Yes.
Did members of his family, of the defendant's family, provide some information that would direct you towards the defendant and continue your investigation focused on the defendant?
Yes.
Did Stephen Lentz, when interviewed, lead you to have additional information that would lead you towards the defendant?
Yes.
So all of those people, when you interviewed them, again, led you in terms of following evidence towards the defendant. Is that correct?
Yes.
Nothing else.
Those people that led you to information about Mr. Anderson, none of them provided any information that they saw Mr. Anderson at Mr. Gutierrez's apartment on May 17th, 2020, correct?
Objection, that's outside the scope of my question.
I think it's exactly in scope of his questioning.
Well, actually, as I've repeatedly said, I'm usually not too rigorous in the application of that rule, but we're getting close to the point where my rigor may return. So you can have an answer to this one.
Could you repeat, please?
That those individuals that the state just asked you whether the individuals you talked to gave you information that pointed you in Mr. Anderson's direction. And I'm asking if any of those witnesses, or actually stating none of those witnesses, provided you information that they saw Mr. Anderson at Mr. Gutierrez's apartment on May 17th, 2020. Correct?
Correct.
Nothing further.
Nothing on that specific question.
All right, you may step down.
Can I have 30 seconds just to talk to co-counsel and just inquire about the next?
Yes?
If, oh, I just.
How many
We'll tell. Yeah, we'll tell.
Brewers fans here? One? One. Two. You don't have to be embarrassed about it. Three, I think I saw now. Cubs? Okay, 3-3. Sometimes there's a few other teams. How lengthy?
Short witness, we've conferred, this will be a very short witness, and then we have a stipulation to read, and then we believe we'll close evidence for today.
Thank you.
Is that accurate?
Yes.
Would you raise your right hand, please? Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God? Please be seated.
Ms. Swanigan, could you please state your name for the record and spell it?
Marissa Swanigan, Marisa, Swanigan, Swanigan.
And are you currently employed in some way?
Yes,
And what in general do you do?
management.
I'm going to direct your attention all the way back to May of 2020. On May 17th of 2020, were you living at the Wood Creek Apartments, specifically 3709 15th Street, apartment 2B?
Yes,
And that apartment, was that on the first floor, second floor, or somewhere else?
the second floor.
So did you have a downstairs neighbor directly below you?
Yes,
And did you know him in passing, just being essentially apartment mates?
yes.
And did you know anything about his family situation in passing?
Just two kids that I would see in passing.
And were they young kids, probably 12 and under, let's say?
Yes,
Did you know if one boy, one girl, two boys?
one boy, one girl.
Okay. And do you recall having contact with law enforcement on the 19th of May of 2020, where they asked you, did you hear or see anything on the day's proceeding that caused you some sort of concern from the downstairs apartment?
Yes.
And what, if anything, do you recall telling law enforcement about your observations that they were asking about?
Just hearing loud banging, like against the wall.
And was this specifically on did you have a specific night that you had heard this?
It was a Sunday night.
So that would be May 17th?
Yes.
And when you heard this, approximately what time was it, if you recall?
Between 10 and 11
And where were you in your apartment when you heard this noise coming from downstairs?
in my bedroom.
And at that time, were you living in a one-bedroom apartment?
Yes.
And was your bedroom at the back end of your apartment, so all the way through?
Yes.
And based on where you were in your bedroom, could you tell in general where this banging noise was coming from?
Yes.
And how are you able to make that determination?
It wasn't coming, the sound wasn't coming directly from under me. It was more so further in front but below me, if that makes sense.
And so in your knowing the layout of the apartment, what room of the apartment below you did you believe this banging to be coming from?
The living room.
And approximately how long do you remember this banging to have occurred on the 17th between approximately 10 and 11 p.m.?
About 5 minutes.
And at that time, did you hear any speaking or any sort of anything else, or just the banging?
Just the banging.
And in your experience as a human being, did you have any sort of thought as to what that banging could be in your mind while you were in bed hearing it?
I initially thought maybe something that was really big might have fell, or if the kids were still there, that they were playing around and they knocked something over.
And you said the banging went on for approximately 5 minutes?
Yeah.
And then once that 5 minutes stopped, did you hear anything further?
No.
And obviously, hearing that banging, knowing that kids sometimes are downstairs, you didn't call 911 that night?
No.
But when asked about, had you heard anything in the days preceding the 19th of May, that's what you were able to tell officers?
Yes.
And you were for sure it was Sunday night between approximately 10 and 11?
Yes.
I have nothing further, thank you.
Prosecutor Hammond?
Thank you. Good afternoon.
Hi.
Hey, so just a couple of follow-up questions. This banging or the sound that you heard, you said in between 10 and 11. Do you remember if it was closer to 11? Do you have a more specific time?
I would say closer to 10, like a little after 10.
And when you spoke with law enforcement, do you remember telling them that you didn't see anyone or you didn't see any cars?
Yes.
Did you look out your bedroom window?
No.
Okay, so you were just staying in bed?
Yes.
Okay. And so all your observations was this sound?
Yes.
And prior to hearing this sound, I hate to go into your whole sleep schedule, but got to do it. How long were you in bed prior to hearing that sound?
Maybe 2 hours.
Okay, and were you awake and in bed?
Yes.
Okay, and prior to hearing this banging sound, did you hear anything else suspicious?
No.
So you didn't hear any screams?
No.
You didn't hear anyone arguing?
No.
And I want to talk about the apartments in general. How long did you live there for?
About 3 years.
Okay. And clearly you could hear what had happened when you heard this banging, but in general, tell me about how private that apartment building is as far as being able to hear what's going on in your neighbor's apartment.
It's pretty quiet.
But can you hear things coming from the apartment across from you or below you?
It would have to be really loud, but if it was, then yes.
And so after you, and you're sure that this was Sunday night?
Yes.
Okay. Did you hear anything the following day?
No.
Okay. Did you see anything the following day?
No.
And were you there the following day, or were you at work?
I was there.
Okay. All day?
I believe I went to work at 9 o'clock Monday night.
Okay. Do you remember telling law enforcement that you didn't hear any sounds of glass breaking?
Yes.
Okay. But you said that, I'm just trying to really get what the sound was that you heard. I know it's hard. I know it was a while ago. And you previously described it as something falling off the wall. But is there any other way that you can describe this sound?
It sounded like just something big being forced against the wall.
Okay. In the living room?
Yes.
I don't have anything further.
No, nothing further, thank you.
You may stick down, ma'am. I think you folks have put in a full day, and it's a good time to stop.
Can we
Can we read the
can we read the
stipulation?
stipulation?
You may.
Okay. Counsel, we're prepared to read the stipulation.
Yes, I would like to read the first part.
Okay. Any of my copy? I'm happy to do that.
Okay, sure, thank
Okay.
you. So cordial. So we have a stipulation. I'm going to read the first part, Judge, and then the state will read the second part. The following are statements attributed to Lene J. Douglas, who is an unavailable witness in this matter at this time. The parties have stipulated that these two statements should be read in their entirety to the jury in place of testimony that Ms. Douglas would have made if she had been available. Officer Paul Chase, on May 19th, 2020, reported, quote, "I did speak with Lene J. Douglas in number 2C," end quote. Quote, "Douglas told me that she thought that she heard an argument from apartment 1B yesterday, May 18th, 2020, afternoon around 13 hours. She knew that the subject in 1B had kids and did not think anything of it. Douglas went on to say that she did not see who was arguing," end quote.
Members of the jury, the second part of the stipulation is as follows. Lene Douglas telephone call on March 10th, 2022 with DA Mike Gravely and Victim Witness Coordinator Heather Beasy. Ms. Douglas was asked about her verbal statement to Officer Chase, in which he had her saying that she had heard an argument in 1B on May 18th, 2020 at about 1 p.m. Ms. Douglas stated that she could not be correct, stated that could not be correct because she was working with headphones on for her job from her back bedroom on Monday, May 18th at that time, and would not have been able to hear anything. She stated the officer must have misunderstood what she told him. She stated that when she heard something concerning apartment 1B, she was in her main living room, comma, it would have been about 9 p.m. because she was watching TV. She stated that it was in the few days prior to May 19th, 2020, when she heard at approximately 9 p.m. a scream in the hallway by 1B. She described the scream as high, as if someone was in pain and surprised. She stated that she could not hear anything further, which surprised her because based on the original scream, she thought she might hear a call for help or something. That's the completion of the stipulation, and of course, this has been filed with the court. It's been provided to the court.
Right. Folks, again, when there's a stipulation, that's something the parties agree as being the true fact. And so that's something that you should accept. And no further proof will be received or received to either prove or disprove what is agreed to. Any question about that? Okay. Anything else?
No.
Okay, let's break for the day. 9 o'clock tomorrow morning. Please don't read, watch, or listen when you encounter the trial. Don't discuss the case even with fellow jurors or members of your household, and we'll see you tomorrow.
Van Wee-Daubert issue. I don't think we've had that yet. And
You're right. Yep, I think that's a good idea. Yeah, this is a good time to tell me get out of here. All right, I have a number of observations on the Van Wheat testimony, or offered testimony. The first observation that I want to make is I thought it was very clear from the argument that has been made here that there is no dispute as to the scientific basis for the methods and principles which were employed in this case, although there's dispute as to the qualifications of Officer Van Wee and the method in which he did his observations and analysis. But I did not understand any dispute as to the basic science of it and the requirement for the admission of this type of testimony, as stated in 907.02 subsection 1, is that scientific, technical, or other specialized knowledge will assist the jury to understand or determine the fact and issue, that the expert witness testifying is qualified as an expert by knowledge, skill, experience, training, or education, that the expert testimony is based upon sufficient facts or data, that the expert testimony is the product of reliable principles and methods, and that the expert testimony has applied the principles and methods reliably to the facts of the case. And the defense objection states that the defendant maintains that Officer Van Wee's testimony regarding his observations and conclusions of the blood evidence is not admissible for the following reasons. One, that he is not qualified as an expert in the field of blood stain pattern analysis. Second, that he does not comply. His report does not comply with industry standards and requirements. And third, that Officer Van Wee failed to reliably apply principles and methods and made substantial errors in his report. And the defense position is largely based on a report submitted by Dr. Marilyn Alice Tebbs Miller, and she has made a number of attacks on Officer Van Wee's performance in this case and the contents of his report. And then we discussed at some length the other day, and I pounced, as I frequently do, when Attorney Mueller talked, we'll start talking about standards and requirements, and I challenged that to basically according to whom, and I think the response was the Department of Justice, and I have to say, I haven't made an exhaustive search, but I haven't found these standards from the Department of Justice. I think I made pretty clear that I'm not familiar with any authority that I'm required to follow standards of the Department of Justice. I'm not familiar with any legal authority for the Department of Justice to proclaim or enforce standards on the state courts. And I'm not suggesting that the Department of Justice may not have done so, but the Department of Justice has done a lot of things that are in the courts right now, actually, and in the Supreme Court right now, as to the reliability and the legality. But even assuming that they've made suggestions as to what standards courts should apply, I'm not familiar with any standards which I am required to employ. Certainly, I've not heard of any constitutional, under the federal Constitution, that I would be required to do so. And I've not seen any that set the standard for state law. And in fact, both the United States Supreme Court, from the beginning of Daubert, and the state Supreme Court, from the beginning of Wisconsin's use of Daubert, has, I think, have deliberately veered away from a course of imposing strict standards on trial judges, and to the point that, as I mentioned the other day, Judge Apremian's article, which is in whatever they call the Wisconsin Lawyer now, I guess it's the Wisconsin Lawyer, comments on Professor Blanca's splendid primer on Daubert evidence, and the fact that Professor Blanca said Wisconsin was a lax Daubert state when it's in assessing what the appellate courts have demanded of the trial courts. And Judge Apremian has not necessarily agreed with that. I think he's suggested that the individual states' laws have really defied easy definition of what is a lax and what is a strict application. But so as I say, I think that Ms. Muller made reference to controlling. I think that was my word, controlling. But on the idea that these standards are to be followed in order for the witness to be qualified, and I don't think there's any control element in it. She's advocating adherence to the standards of the organization to which she pays dues and belongs, and I think has been an officer. But why they would be preferred to a lot of other criteria. And I mentioned the other day that I thought they were very firmly rooted in an academic approach, and for example, suggesting that to be qualified for this analysis that was done here, that the officer ought to have had a bachelor's degree and have taken a course in trigonometry. And I've been in this position for 40 years. I was district attorney in the district attorney's office for 6 years, and in private practice for I think 7. And I have had this type of testimony come up numerous times, most notably in a case called State against Perez, which I won't get into. But trigonometry was never part of my analysis. Now, I'm not saying it wouldn't be an improvement of my analysis to apply some trigonometric principles, but first I'd have to take trigonometry because I didn't. And I suspect many of my colleagues in the judiciary would not have taken that course or those courses, and even a lesser number of police officers, including those who've done a lot of this work and we've relied upon for many, many years in the criminal courts, that would not be viewed as a prerequisite qualifying as an expert. I understand there were some substitute courses in that, but as a general statement, I did feel it was the viewpoint of these standards, which, well, I think they appear to be a product of the academy, and they are biased in favor of an academic background for the examiner rather than an experiential background. And from what I've read on the topic in case law over the years, both from Wisconsin and from elsewhere, as a general statement, I think the vast majority of the persons who've qualified to give opinion in this subject, while many of them have taken academic programs and have degrees of various types. But it's very likely a experience-based science. And Professor Blinka gives the example of the perfume tester who tests and distinguishes between 140 different perfumes from experience alone by smelling them. And there's no way you could scour the world, even at the Sorbonne, and you'd not find someone with the credentials to do a better job than someone who's just been doing it for a long time. So I'm not saying no that the doctor is wrong about this, and she's trying well to try to move this into a more disciplined area, and certainly education is a component of that. When I say education, we get education a lot of ways. Sometimes just by failing. But so she's trying to get more standards and ensure that the people are having some good background in some other aspects of blood stain examination and opinion. But I don't think what she's advocating, what these standards, as they're referred to, suggest are prerequisites to admission of the testimony and analysis of someone who is otherwise knowledgeable. And I remember there was some of you may remember it, but I certainly do. When Daubert was adopted in Wisconsin, there was almost a panic. What's going to happen? And hearing two different presentations, one by Professor Blanca and the other by a judge from a magistrate judge from the Western District, whose name I have to apologize, I don't recall, and also a presentation by a judge from the Court of Appeals, who was a judge in Janesville, and embarrassed now, I can't suddenly come up with it. Very knowledgeable judge. And they all gave basically the same message. There's not much change from what the rules were pre-Daubert. It's my own opinion, from having lived through that period and having tried cases under the pre-Daubert approach. There was there was a word for it that's widely used at the time. You don't hear it too much anymore. Since Daubert, there was a lot of junk science coming into the courts. And I heard things said on the witness stand that I think, you've got to be kidding me. But we had such loose standards in those days about who qualified as an expert and what opinions those experts might convey. That's what was the driving force in the adoption of the Daubert rule in Wisconsin. But these very capable people with terrific federal experience who had worked with Daubert said there's not that big of a change. There is no doubt in my mind that under pre-Daubert approach, Officer Van Wee would have qualified. There are only a few areas where I think the defense has scored some legitimate points, and I'll get to those. But in terms of the first 5 areas of the inquiry, whether it's really a science, whether it's verifiable. You made mention, Ms. Miller, of the peer review. And see, to me, the peer review referred more to the determination of whether this is really scientific evidence and had been tested, and that there were available statistics as much as possible for its reliability. Well, does anybody know, was the issue of the so-called shaken baby syndrome ever been resolved ultimately in the courts? You used to hear that. I used to go to judicial programs all the time, and we'd spend days on shaken baby syndrome. Only the last time I ever heard of it was a presentation with some very eminent scientists and lawyers, and the consensus was that there's no such thing. I haven't followed up on it since. I haven't had a case like that come in here since. I don't know if Daubert spelled the end of that or if it's still being pursued, but there were enormous amounts of money being taken from one pocket and put in another on the basis of those lawsuits. Same thing with the tire cases that the Campbell, is it Campbell? Campbell case, and the breast implants and the needless suffering which was endured because of people being afraid, because of what in the end wasn't really accurate science. That was what I think the objective was, is to shoo that stuff out the door. And peer review was part of that. Whether when you made a Daubert analysis, whether it was verifiable information or just somebody's theory. I had a person come in here from an academic background and testify that when a person is driving an automobile and is going to turn right, that motorist will always initially start to turn left to set up for the turn. I was embarrassed to be submitting that case to that jury with that kind of information. So that was, I think, what the Daubert rules were aimed at and have largely accomplished. But I have to say, having lived through now 10 years of Daubert, 10 plus, I haven't noticed the difference. I'm just seeing less of the junk. So in terms of the what Professor Blinka refers to as, in his article, March 2011, Wisconsin Lawyer, Well, at page 18, these three foundational elements, relevance, qualifications, and helpfulness, are the target of the rule. And under 907.02, the qualifications element should speak to the reliability of the witness's principles and methods and their application to the facts. He comments, experts sometimes, he's quoting, experts sometimes reach different conclusions based on competing versions of the fact. And that the rule is not intended to authorize a trial court to exclude an expert's testimony on the ground that the court believes one version of the facts and not the other. And I made reference to that on the first day we discussed it, that while I have a gatekeeper duty, this is not my decision to make. This is for the jury. Professor Blanket continues, there is no definitive list of reliability factors that must be applied in all cases, nor is there a hierarchy of factors that ranks them in order of preference or weight. Which factors apply and how they are weighed are within the court's discretion. This is a much misunderstood aspect of the reliability standard. In Dauber, the Supreme Court discussed 5 non-exclusive factors in the context of scientific evidence. 6 years later, it quelled a circuit split when the court clarified in Campbell attire that the reliability analysis also applied to non-scientific expert testimony. But he goes on. On page 5, no, 19, page 19, at point 2, whether the technique or theory has been subject to peer review and publication. And I don't think either the general technique or the theory are at issue here, and that they have been widely subject to peer review and publication. And I don't think there's any question now. I shouldn't say any, because I'm aware that there is one case that's ongoing now that raises some issues about its reliability. But I won't get into that because I don't think it has anything to do with this case anyway. But and the Supreme Court said, moreover, Rule 702 is broad enough to permit testimony that is the product of competing principles or methods in the same field of expertise. Finally, the United States Supreme Court has expressly recognized that the trial judge must have considerable leeway in making reliability determinations. Disputes among experts centers on the principles and methods. The focus must be on the principles and methods. Appellate courts give short shrift to trial judges who unduly focus on the witness's qualifications. The court is required to make a separate finding that the witness reliably applied otherwise reliable principles and methodology. At page 60, professor says, experience alone or experience in conjunction with other knowledge, skill, training, or education may provide a sufficiently reliable basis. In certain fields, experience is the predominant, if not sole, basis for a great deal of reliable expert testimony. Getting into Dr. Yes, Miller's report. She's made some observations of this, about this case, the most glaring of which was brought up by Mr. Gravely the other day, that she, as I said, I thought she succumbed to what a lot of us do now in the computer age and just took an earlier report and made some modifications. Nothing wrong with that. Made some modifications and issued it, but at page 4 of her report, Exhibit 3, that you've offered for the defense, during my review of Officer Van Wee's report and the case materials, including crime scene photographs, autopsy reports, and forensic laboratory testing results, I was able to identify several blood stain pattern identification errors made by Officer Van Wee. Well, of course, there was no autopsy, so she's grossly misstated what was available for her in her critique, in order to make her critique. In reviewing Officer Van Wee's report, he has experience. I heard a former police official being interviewed on television last night. I think the individual was from New York, but while New York's problems get more publicity, its experience is repeated around the country. This person, who was very high placed in the New York Police Department, if I'm right about the community, said, we can't get police officers anymore. It's been made into a very unpopular occupation. It's a dangerous position. Number one, it's dangerous just in doing that line of work, and I understand there was a police officer killed in Chicago again last night, one in Milwaukee a couple of weeks ago. And then these people have to make life and death decisions in less than a second. There was one on trial in Milwaukee 5 or 6 years ago, and Attorney Smith used to be with Jerry Boyle. I can't think of his name.
Jonathan
Smith.
Yeah.
Defended him, and he had there was a video of the incident, and there was no question. The district attorney didn't even claim that the officer's first shot, which was non-lethal, was legal, but in, I think, about 0.7 of a second, the officer took a second shot, which was fatal, and got criminally charged for something that happened in less than 1 second. It's a big disincentive to taking that kind of a job. So there are decreasing. I think the particular, I may have read this in part of this in an article too, just this morning, of someone talking about the lack of applicants for police jobs and how we used to have 500. No, it was Chief Deputy Levin who retired the other day, and he said we used to have 200 people apply for these jobs, and now we have, I don't know if he said less than 50 or if he said 20, but that's the problem. So where do you get all these qualified examiners if you impose even stricter criteria for them to testify as experts in the court? So you not only have to, you already have a limited number of people applying for these jobs, much less than in years gone by. And then to go with everything else, and of course there are some officers who either make mistakes or in some cases worse, but some people will paint the entire profession with just awful accusations when they're just trying to do their jobs properly. So you have an already diminished number of applicants, and then to take those limited number that you have and say, in order to do this work that the police desperately need to have done, they have to have blood stain analysis done as part of their work. They have to employ only those who have completed trigonometry courses and have a degree of various academic stature. So that is not part of the calculus for me in determining who's qualified as an expert. And I think Officer Van Wee testified very capably about his experience credentials. And yet the defense says at page 3 of its brief, or its motion, the only qualifications the state claims is that he has experience as a police officer and completed a 40-hour course in bloodstain pattern analysis. Skipping. Additionally, a 40-hour course did not make someone an expert in the respective field of study. But there's no support for that claim. I didn't see any citation to any authority that one can't learn this particular scientific analysis in a 40-hour course. I'm not saying it can, but I'm satisfied with all of his credentials, all of his experience. He is shown to have sufficient experience to qualify as an expert. The defense characterizes at page 4 Marilyn T. Miller a national expert on blood spatter. I don't know if she is or not. I never heard her name before. And there's no citation of that, and that's always, of course, something that isn't easily quantified anyway. There are, I'll still say, I don't care what anybody says about Willie Mays or Mike Trout. I'll still say that Henry Aaron was the greatest baseball player of all time. So, you know, that's just somebody's opinion. So I don't know who said she is a national expert on blood spatter analysis, but it did. That's an unsupported claimants. As far as I'm concerned, the defense quotes from her report about how he doesn't have the undergraduate degree with coursework and trigonometry and science-based coursework, and specifically laboratory work in biology, physics, and chemistry. I don't see where that's necessary to the job. I really don't. And in the event this ends up in a different court taking a look at it, I don't know. I just don't see those as prerequisites. Documented mentorship program, those would all be positive and pluses, but in terms of the reality of the world in which we live, I do not embrace that claim. Not being certified with the International Association of Identification, that would not make a big difference to me. These standards, so-called.
Judge, I'm sorry to interrupt, but
Oh.
I really need to use the restroom.
Oh, yeah, by all
So-
means, go ahead.
Okay.
No,
Or if-
I'm almost
if we
done, but
could-
I don't want you to wait. No, go.
I can wait if it's going to be, if
No,
it's going to be
I would never
quick.
do that to someone.
I'm telling you I can wait,
Well,
but I want to be sure that I'm not, I don't want to feel like I'm rushing anyone here.
I
but-
don't feel rushed.
Okay, so I can wait, but if it's going to be like 20 more minutes, I probably will want to take a break.
Let's we'll compromise. You can stay and hold on, and I'll finish up within 5 minutes.
Great. I appreciate it. Thank you, Judge.
But feel free to,
If I need to leave, I
Yeah,
will, and I'll
yeah.
leave John and Kirk here.
all right. These standards, they didn't even start assembling them until 2 years before this incident. So, now, there is something about Officer Van Wee that I do think the defense makes a good point. He's not going to be permitted to testify to what was and was not blood, because he hasn't got credentials for that. He can testify to what looked like blood, whatever characteristics he wanted to see, which probably wouldn't be expert material anyway. And somebody who walks into a scene like this, a totally lay person, is perfectly capable of very quickly falling into discussing it in terms of it being, oh, there was blood all over. But he's not going to be able to characterize anything as blood, at least not on his own credentials. And this is a business about his usage of the terms, the victim was attacked in the hallway outside his apartment door. The bloodstains indicate the violent attack continued. To the extent that that is prejudicially emotive, that's got to be controlled. This is not an exercise for him to advance a theory of how the crime happened. His job is to report what he saw, and what he's qualified to report on is the pattern and the like. And I think I'm going to wrap it up with that. So that's the reason I gave the ruling that I did. And what did you have to say?
So he would be able to testify that it looks to him like blood based on his experience. There literally is no one in Kenosha Police Department who's dealt with things in
Yeah,
blood
he's.
more than him.
I would expect someone with even a few months, definitely a few years on any police department, at least around here, to be able to say, use the word bludge with considerable reliance.
So he's allowed to express his opinion that it's blood. He's just not allowed to, he's not allowed to
When he's
definitively
talking scientifically, no.
Say it one more time.
He can't do it scientifically, no.
Similar to what we just had.
We'll work it out. I'm not worried about it.
Okay. So I understand. Thank you.
Thank you.
Thank you, Judge.
What did I tell you, 9 o'clock?
9?
Yes.
Yeah.
You told the jury 9. Yeah.
Okay, please don't read, watch, or listen to the account of the trial. And enjoy the evening.